May I please your lordship, my lord? Lordship, in item number 6, lordship, we have filed one affidavit, lordship. That record may be kindly.
अतुल मैडम का नंबर वगैरह तुम्हारे पास है इनकेस लिंक में होगा चलो ठीक है कोई बात नहीं
Item number 11, Lordship, with consent of the other side, matter may be examined for a day, Lordship. The arguing counsel, Sikha Singh is not well today, Lordship. Arguing counsel, Sikha Singh not well today, Lordship. Suffering from diarrhea and high fever, Lordship.
Is there any stay?
बेटा
What is the matter about?
Matter about my lord, stall in railway platform, my lord.
Oh, that matter.
Yes, that
Okay.
matter, my lord.
We grant your, but vacate the stay. Take whatever you feel.
Matter is there may be continued, Lordship.
No news. This is the instruction I have. Last order.
Yes.
That is the stand of the government, Lordship. First. Second thing, Lordship, I would like to impress your Lordship. So far as this judgment, Morley MS is concerned, Morley MS, Lordship, on the basis of which your Lordship was intending to send the matter to the HPG Lordship. So my submission is that, and my understanding is that this high power committee was constituted only for the purpose of transporting elephant to the camp of the respondent number 3, both in the High Court judgment passed by the Tripura High Court and in this judgment, Lordship, Morley MS. In Tripura High Court, Lordship, respondent number 3 is the Bandara camp, Lordship. If Lordship comes to paragraph 4, Lordship, the petitioner submits that respondent number 3 is a trust. Lordship, this is the same trust, Lordship. Respondent number 3 trust came before the Tripura High Court, and the respondent number 3 trust before the Supreme Court in Morley MS is the same trust. Lordship will find that last line of paragraph 1, Lordship, Ramakrishna Temple Elephant Welfare Trust. Now, this is a component of Bantara, Lordship. To that aspect, Lordship.
You see, Kindly come to paragraph number 9 of Murli. 8 and 9.
Lordship. So in the Tripura High Court, Lordship, 24 numbers of element from Tripura and Arunachal Pradesh to the respond number 3 camp. It was, extended pan-India Lordship. Now it is from Kerala to same camp.
Read paragraph 8 and 9 of the judgment.
Yes. No, that is why I am submitting Lordship. This High Power Committee was constituted only for the purpose of transportation of animal from Tripura and Arunachal Pradesh to camp of respond number 3.
Mr. Nayak, kindly read paragraph 8 and 9 of the judgment.
Though the scope and jurisdiction of the High Court Committee was limited to the High Court, limited by the High Court, to transfer of elements from northeast part of the country to the elephant camp in respond number 3.
गीत को फोन करके
We see no reason not to extend it to pan-India, particularly when by extending the jurisdiction of the High Court Committee at pan-India, earlier it was Arunachal and Tripura, pan-India level, will not only serve the real public interest and would advance the cause of welfare, care and rehabilitation of wild animals, but will also curb the filing of frivolous PILs before different high courts by VGBs. That is 9.
Paragraph 9.
In view of the aforesaid facts and circumstances, we deem it appropriate to extend the jurisdiction and scope of the High Powered Committee, as constituted by the High Court of Tripura, with the modification that the chief wildlife wardens of the states to which the issue relates will be co-opted as members of the said committee. Earlier it was only Tripura and Arunachal Pradesh, now it penned. Said committee in place of civil wildlife wardens of Tripura and Gujarat throughout the territory of India, leaving it open to the committee to conduct necessary checks and to undertake fact-finding exercise in any pending or future complaint in this regard. The said committee may also consider the request for approval, dispute, or grievance concerning transfer or import into India or procurement of or welfare of wild animal by any rescue or rehabilitation center or zoo. We do not fall into this category. By taking assistance and cooperations whenever needed from all departments and authorities across India, we also direct that all complaints in this regard may be forwarded forthwith to the High Powered Committee for consideration and recommending appropriate action. So that is there. Next paragraph, Lordship will.
Then you come to the order of 12/5/2020.
Prerna Singh.
Then Prerna Singh Bindra.
Prerna Singh Bindra.
12/5/2003.
Yes, para 5 onwards.
No.
Para 5,
Later.
para 2 starts the whole thing. And then para 5 is very relevant. The need to shift para.
Later is the-
Yeah. Maybe it has been written.
Respondent Kuncha.
Have you got the judgment?
Yes, Lordship.
Kindly come to paragraph 3, paragraph 2.
That is already there, paragraph 9, Lordship. So far as paragraph 3 is concerned, in view of the extended ambit of the committee, this court directed that the chief wildlife wardens of the state would be co-opted as members of the committee in place of chief wildlife wardens of the state of Tripura and Gujarat. That is paragraph 9, Lordship. So only direction is paragraph 5, Lordship. These are the issues which are also to be considered by the High Court Committee.
Duration of ownership certificate in relation to elephants.
Transfer of elements to the respond number
Wait,
3,
wait,
Lordship.
wait. Inquiring into the capacity of the facility where the elephants are proposed to be transferred. Monitoring of the health and age of the elephants. Monitoring the facilities for transportation. And the need to shift the elephants.
Lord,
The HPC contains expert within the chairperson of the AC is committee is permitted to co-opt a member. The remit of AIA would comprehensively cover all aspects, including those which are sought to be raised on behalf of the applicant as noted.
गया उन्होंने सर लेकिन उनका अभी तक रिप्लाई नहीं आया जैसे आएगा
Mr. Counsel who is
किया है
there
क्योंकि
on
किधर
VC,
है
Mr. Counsel who is there on VC, kindly keep your audio off. When you make your submission, you can put it on. Aspects including those who are sought to be raised on behalf of the applicant as noted above. In other words, all as relevant aspects are entrusted to the making process of the HPC. So therefore, you have to now say before this court that it is your case is outside the scope of all these things. If you say, we take it up. Your competent authority who has given this particular thing, they are more concerned about the elephant's health. This aspect is now within the scope of the high power committee. So if that is so, because the basis reason on which the competent authority says that we need to fight for the elephant is that the persons who are keeping the elephants are not keeping the elephants in a proper manner. So therefore, the question as to whether the elephants are being kept in a proper manner and all falls within the domain of the HPC. So wouldn't it better for you? You will have your own chief warden, will be there a member. He can very well fight it out for the state instead of pursuing out here in a writ proceedings. Because once it goes to the high power committee, it's now an expert body. With this expertise, they can very well pass appropriate directions as to how the elephant is to be kept, how not. They will have those facilities. They can rope on many other members. This is the scope and ambit of the High Court, of the Supreme Court. So therefore, on the basis of that, the High Court committee can very well look into it if the elephant is not kept in a proper condition. Whether the state of Tamil Nadu can contest or the particular respondent number 11 can still keep the elephants, it is absolutely within the domain. You can very well put forth your case out there.
That aspect will definitely your lordship will consider. But another aspect is there.
Unless, Mr. Nayak, you want to keep this matter pending.
No, lordship, in this petition, what I'm basically trying, lordship, other issues are settled. So far as the legal issues are concerned, that is not on the dispute, lordship. Not at all in dispute. Only we are praying for a direction to the state of Tamil Nadu to discharge this administrative duty, lordship, nothing else. They have already admitted everything. They are ready to, ship the elephant to the state of Assam. That much they have accepted. Even state of Tamil Nadu is not even, any disputing that it is a dispute between the state of Tamil Nadu and state of Assam. Only the temple committee, Lordship.
That's not correct, my lord.
No, from the materials on record, it is apparent that the state wanted to give it to you earlier.
Lordship.
But later on, they have taken a policy decision or whatever may be, they have put forth before the Madras High Court. And before the Madras High Court says that they will fight it.
No, Madras High Court has not passed any order, Lordship. Not even a direction, Lordship.
Obviously,
Yes.
it's not. So therefore, they took a stand before the Madras High Court, and therefore, the Madras High Court closed the PIL or whatever may be.
Lordship.
That's it.
So Madras High Court only said respondents are not going to send back the temple elephant to Assam, and that the respondents would take care of the temple elephants in the best possible manner. We do not find reason. So court said nothing. We do not find reason to give any further direction to the respondents to take
Isn't
care
that
of the
what
elephants.
Mr. Nayak I just said?
Only to that extent.
They
yes.
had given a submission that they are not going to transport the elephant back to Assam. And therefore, the Madras High Court closed the proceedings. That's what the Madras High Court did.
Yes.
So now, when your competent authority's basic grievance is that the elephant is not kept well, that you need the elephant back, and basic idea is that the elephant is not kept well. So therefore, wouldn't it be for the species to decide, taking into account the scope which is now being enlarged to the particular commission, the HPC?
I understand, Lordship, whatever your Lordship is, I mean,
You see,
in the interest of the
you
elephant,
see
Lordship.
what problems you have in this proceeding. Let me tell you. You have a problem with your own locus.
that I will satisfy your Lordship.
I'm telling
That
you.
I said, the moment
That is-
temple committee becomes a party Lordship, that is easier for me to satisfy your Lordship.
Okay, satisfied.
This is not a conflict between two states. Temple committee is also there.
Very well.
They are not state Lordship.
So how do you file a writ petition?
That is what I'm submitting, Lordship. Just one judgment I would like to place, Lordship. It's a three judges bench, Union of India versus State of Rajasthan. I'm not reading the entire judgment. Just one paragraph, Lordship, paragraph 7. Very small paragraph. The Constitution bench ultimately held in the above case that if a private person from the corporation was also implicated as a party in the dispute, could not be tried by the Supreme Court under Article 131 of the Constitution. So he is not a state Lordship. I mean, temple board.
No,
Lordship.
not on that. Forget about 131 will come later.
Yes, Lordship.
How are you maintaining a writ petition under 226? You are maintaining a writ
Lordship,
petition under 226.
Lordship, only option open before me either Article 131 or 226, Lordship.
No, whether if the option is not being given by anybody, doesn't mean that you are invoking 226.
Yes.
What
Lordship,
is your constitutional right over the elephant?
that is already, I mean,
No,
before
no,
your
you have to
Lordship.
say there is a violation of your constitutional rights.
No, I'm not saying that that is not even a dispute, Lordship.
No,
we
no.
have issued the ownership certificate.
Understood.
We
Now,
have issued the transportation.
whose constitutional rights are being violated?
No, what we are praying, Lordship, only a direction to the state of Tamil Nadu.
Understood. Why do you need? My question is, what is your constitutional right which have been violated? My question is that.
Lordship, more than my right, Lordship, it is the right of the elephant, Lordship.
For the right of the elephant, HPC will look into it. I'm asking you, what is your constitutional right?
If your Lordship has already decided, Lordship, in that situation, I have nothing.
No,
but
no,
to submit.
no. Not on that. I am not. My question is, where is your constitutional right? You approached this court on violation of a fundamental and a constitutional right.
Lordship,
What is your right?
Lordship, recently one judgment was passed today. That copy is not with me by Bombay High Court, Lordship. There the court was considering the right of the elephants, Lordship. And the court ultimately held the basic right of an animal is to allow it to grow in natural inhabitant. That is the elephant right, Lordship.
Absolutely. There's no quarrel with
Now,
that.
who will ensure that right in that situation, Lordship? If the state of Assam has no right.
For that, the HPC is there to look into that. Therefore, my question is,
that is-
Mr.
that
You see, the problem lies there. Paragraph 8 says, of Murli's judgment says, we are extending the period, extending the scope of this HPC on the ground that if this HPC looks into it, they are an expert body, one. Secondly, unnecessary frivolous litigations would or not be there. Anybody is aggrieved, they can be approached the HPC. So therefore, if you are concerned about the well-being of the child of the elephant, it is for you to take it up with the HPC. That you look here, the HPC, the persons who have, we have transported it to the state of Tamil Nadu on the basis of an assurance that they would hand it back to us after 3 years or 6 years. They have not. Initially, they said they are. Later on, they have given up. In the meantime, this particular elephant is kept by the respondent number 11 in not a condition which is good. So therefore, kindly take it up on this aspect. This is your case.
I understood, Lordship, but my only doubt is whether this with this judgment, Lordship, applies in a situation in our case, Lordship. In all these cases, issue was transportation of animal
No,
outside
it
of
was
the respective.
you see, the problem lies because monitoring of the health,
That is there. But here, Lordship, what you are
the
considering.
manner in which the
retrieving of an
elephant is kept,
Yes.
this is within the scope of the HPC. So you have to carve out a way by which you
Lordship
don't
will-
come
Lordship-
within this scope which is being mentioned by the HPC.
Lordship will once again take note of that paragraph in Prerna, Lordship. Lordship, ultimately the issue was transportation of animal to the camp of respondent number 3. Court said in this judgment, Lordship, Prerna Singh, while remitting the matter to the HPC, these issues will also be taken note of. But the basic issue remains the same, transporting animals to the camp of the respondent number 3.
See, what did the in judgment in Murli say? Murli said Tripura High Court had framed only for this purpose. Only for this purpose. The smaller issue.
Lordship will once again, Lordship will appreciate me, Lordship. Transportation of element, 24 numbers of animals from Tripura and Arunachal Pradesh. MS Murali, now it was from Karnataka. Court said, no, it will be pan-India. HPC remains the same. HPC was constituted by the Tripura High Court. HPC remained the same. Now, instead of Tripura and Arunachal Pradesh, all the states, that is the extension, Lordship, pan-India extension. Issues has not been extended. Lordship, may kindly see what are the additional issues. Lordship, court said, the said committee may also consider the request of approval, dispute, or grievance. One additional issues were there. Concerning transfer or import. Lordship, here, additional what?
State committee may also consider the request for approval.
No, in
dispute,
this
or
case,
grievance.
Supreme Court framed some additional issues, Lordship. Those additional issues I am trying to show your Lordship. Lordship 9, third line, with the modification. So what directions were there? With the modification that the Chief Wildlife Warden of the state of Assam, that is okay. Leaving it open to the committee to conduct necessary checks and undertake facility. The said committee may also consider the request for approval, dispute, grievance concerning transfer, import into India. Approval, dispute, or grievance concerning transfer or import into India by taking additional issues.
Or procurement or welfare of wild animals by any rescue,
Paragraph 12, Lordship. Paragraph 12.
rehabilitation or zoo by taking assistance and cooperation whenever needed for all departments and authorities across India. We have also directed that all complaints in this regard may be forwarded forthwith to the High Power Committee for consideration and recommending appropriate action.
Paragraph 12. The above directions issued by us are in addition to the directions contained in judgment dated so and so, Lordship.
Para 13 also.
So this direction is paragraph 9, Lordship. If Lordship comes to this 2-line, Lordship, import into India or procurement of welfare of by any rescue or rehabilitation center or zoo, not by others, Lordship. By any rescue or rehabilitation center or zoo, paragraph 9. So my understanding of the law is that here, Lordship, we are praying for retrieving of the elephant. And the issue discussed in these judgments, Lordship, are transportation of elephant to other states. I admit, Lordship, one paragraph is there, paragraph 10. Lordship, may kindly see that paragraph. Paragraph 10. সিজার শব্দটো সিহঁতে ইউজ কৰিছিলে ন সিজার শব্দটো সিহঁতে যিখন আমাক লিখিছিলে ইউজ কৰিবৰ কাৰণে 5 লাখ টকা লাগিব। Yes. Yes. সিজাৰটো পিটিশনত তোমাৰ পিটিশন
Now, Mr. Tiwari, tell me, the HPC has power have been extended,
Yes.
but how do you enforce an order passed by the HPC?
I beg your pardon, my lord.
The HPC's power is had been extended, but how do you enforce a order passed by the HPC?
Once, my lord, since HPC has been constituted by the Supreme Court, once HPC takes a decision and gives a direction, those directions are binding on the states.
How? That power has to be given by somebody somewhere.
I would submit that the power has come by the order and direction of the Supreme Court.
Just
Just
for
like in
example,
Visakhapatnam.
just for example, in this T.N. Godavaran's case, you have a central empowered committee. Now, this central empowered committee, though appointed initially by the Supreme Court, but later one was notified by way of a notification, thereby granting it the powers. A power cannot be granted to, you see, it is a concept of granting a power to do something is different from that power to exercise and enforce it. Now, how will the HPCA exercise that power? HPCA tomorrow may say, okay, this elephant should go to Assam. Very well, understood. But who is going to enforce it? Where is the direction? Where? There has to be somewhere, the Supreme Court might either have said that it would be treated as the decree of the court and all. Just for example, in the case of an arbitration, it says that it will be treated as a decree of the court and therefore it has the force of a decree for the purpose of execution.
I concede, my lord, that there is no
If that is not there,
there is no legislation, but
wouldn't that the HPC be
a body without authority and power. This is what
body,
is
no, body to adjudicate but not to enforce?
I'll put it this way, my lord. There are situations wherein, my lord, the moral authority itself works. Here, my lord, the state of Tamil Nadu has agreed in principle that whatever SPC
No,
decides.
you are digressing from the question I am putting it to you. My question is very specific. Where is the power of HPC to direct and enforce?
That power is not there, my lord.
If that power is not there, but why should I remand it or ask them to refer it? The power has to be there somewhere.
I'll put it in two ways. Number one, my lord, apparently, from the reading of the orders.
Unless
it is
there
evident-
are other orders. What has happened? The Tripura High Court had appointed a HYPA committee. Now let's see the High Court, the Tripura High Court's order. It's irrelevant,
Sudeep Tana.
whatever may be the name.
Paragraph 28, my lord, possibly will help.
We hereby appoint
28 and
HYPA
34.
committee under the chairmanship of so and so, so and so, so and so. All members shall the members shall carry out the detailed so and so, and they shall be entitled to interview, question, and so and so, so and so, so and so shall in the person make a report. Shall make a report and provide a statement of this so and so. The chairman then shall have the recommendation of the elephant wise and the recommended not recommending the completion. Recommends any elephant should be transferred. And the concerned so and so shall take
LMN.
steps to either confiscate. Is the chairperson.
The
of
Lordship will not skip
committee
E, F,
determines
G,
that
H,
an
Lordship.
Elephant or elephant should be transferred, then the concerned chief officer shall take steps to either confiscate the elephant or take an undertaking from the concerned owner that the elephant shall be taken off without any cruelty. In case where undertaking is not given, the chief engineer shall be bound to monitor the elephant concerned. Recommends the elephant so and so. Also to the camp of elephant shall ensure that the
Lordship
what
may
has
see-
happened? We direct all police authorities to do so. Officers so and so. Now, as per Murli, what was done, this was made pan-India, and the chief wildlife warden
the respective states.
states have been given. So therefore, if we see now,
L
L,
and M also, my lord.
no, L.
L. In case the chairperson of the committee recommends that an elephant or elephants should not be transferred, then the concerned chief wildlife warden shall take steps to either confiscate the elephant or take an undertaking from the concerned owner.
So
that
this is a
elephant-
power which is on the basis of a direction. This direction is now being issued.
Yes.
This is a power exercise under 226. And by this order, it is the recommendation which is being made is enforced on the dint of the order passed by the Tripura High Court.
That's it.
Okay,
That is the legal cover.
that's the legal cover. This is done under 226. Now, what has happened in Muli? The only scope is changes the wildlife of others. But how do you enforce it against the state?
My lord, the only logical explanation possibly could be that in view of the judgment of the Tripura High Court in Sudeep Tanath, the states are bound by the recommendation of the HPC, and it would be the duty of the concerned chief wildlife warden to enforce the decision of the high-powered committee.
To
That has
confiscate.
been given, yes. That
And
has
then
been given all India.
the committee recommends here
is
the
the-
chief judge shall ensure the transfer of elephant is undertaken in the most appropriate manner conducive to the elephant, and further concerned so and so shall request the jurisdictional police to ensure smooth here. Now, how do you bring O?
We direct that all police authorities, officers of forest and wildlife departments,
Now
officers
this
of
will
the
be
Textual Zoo
qua.
Authority.
This will be only qua. What Tripura?
But my lord, the fact that in Murali, the scope has.
This was not made.
My lord,
So therefore, he can only make a request to the police.
my lord, that's one way of looking at it. The other way would be the Supreme Court did not dilute the recommendations of the Tripura High Court given in the Sudipta Nath case.
But
Supreme
Tripura,
Court widened the scope.
but the Supreme Court made it very clear that the directions which were given to the police authorities will also apply pan India. That is
Yes.
not there.
That is
Not there.
specifically not there.
Now, but when the Supreme Court categorically only mentions about the wildlife warden, it will be for pan India for the respective state. So the enforcement has been done through the wildlife warden.
So ipso facto, my lord, the police authorities would also come in. That is going to be
But
my
that
submission.
how is it possible?
Because finally, my lord, when the states agree or the state agrees, yeah, the CC, law has not been.
And who is the second writ petitioner? There is another petition, no? From Bhupen Sharma. Who is that person? There are two writ petitions, or there's another case?
There's
No,
only, this is the only
i-
petition.
Originally, it was the Safe Wildlife Warden Lordship. Now it is one Commissioner and Secretary to of the Department Lordship. Second is State of Assam.
That is not what we understood. This is so that actually the plan India that's understood. That's it.
And now, anything happen after the Prerna judgment?
My lord, I couldn't lay my hand on anything. There is one more.
What happened
process
in
to
the-
Mumbai High Court.
There are other cases also, Lordship of Bombay High Court, where the Lordship may peruse this order.
That is Vantara thing. It was sent to Vantara. That kind of.
This is with regard to Madhuri, Your
So
Lordship.
Lordship will see all these judgment in respect of Bantara only, Lord. Respondent is the same everywhere.
Who?
Bantara, that is Ambani
Petition
Trust Lordship.
Under Article 2 for the consideration of India challenge.
Radha Krishna Temple.
Same trust Lordship. It's a component of Bantara. And these are two, no?
Lordship, there are 3 rehabilitation centers, Lordship, including Vantara. We are not on the.
We can do one thing. We refer this dispute to the HPC. Keep the writ petition pending. And on the basis of the recommendation, if necessary, appropriate directions be passed.
Lordship, may kindly see paragraph 10 of, this Murli MS, Lordship. One
Mr.
provision,
Counsel, you
just one line, Lordship.
are you in
not
favor of the elephant or not?
Yes, Lordship.
So
What
if I'm trying to help you out, don't come up with this
I
thing.
understand, Lordship. I understand. Just one.
No,
line.
no, no. This court will dismiss it.
No, I understand, Lordship. Lordship will
will
just
dismiss
take
it
note of
for-
one line, Lordship.
I will dismiss this.
Just
writ
one
petition.
prayer, Lordship.
No, Mr. Naik. It doesn't seem that you are coming bona fide, Mr. Naik. It is absolutely not bona fide. I am trying to help the state, taking up with the HPC, and after the HPC to submit a report before this court, and thereupon, if necessary, will pass necessary directions. But it doesn't seem that the state is interested in doing so.
Just one
What
prayer,
you are
one
interested
prayer.
in the continuing of unnecessary litigation before this court, I think this will come strictly within the ambit of paragraph number 8 of the Supreme Court judgment. It's a case of bogus litigation by the state.
Lordship will
I'm
give
telling
me
you.
an opportunity, just one line,
No.
Lordship.
I'm going. to
One line.
dismiss-
No, I'm not,
Division bench will help you out. I dismiss it.
Lordship,
You
just,
don't have locus on under 2 to 6.
No.
No constitutional
I have
rights. you
absolutely no objection what your Lordship is saying, Lordship. Just one
Heard
line.
No. Heard Mr. P. Nayak. the
Lordship,
learned
just,
counsel.
I am praying for let
Yeah.
the state of Tamil Nadu seize the elephant, keep it in its custody, Lordship. Then the matter will be sent to the HPC, Lordship. Paragraph 10, that is why I am referring, Lordship. Of the Murli MS, Lordship. Just one paragraph, Lordship.
Yes.
Paragraph 10, Lordship. We further direct, I may have some, reservation so far as constitution of the HPC is concerned. But if Lordship is at all referring the elephant to the matter to the HPC, we further direct that all the state and central authorities shall forthwith report seizure of wild elephants or abandonment. I'm not to the remaining portion. The state of Tamil Nadu has given us an assurance that Lordship, we will seize the elephant, captive elephant, and keep in our custody, then we will transfer it to you. Now, to that extent, Lordship may direct Lordship. Let the state of Tamil Nadu seize the elephant.
Yes. You do it at your own cost. You want to protect, keep it, so keep it.
Because, my lord, so far as we are concerned, we are regularly monitoring.
No. You
Sorry,
keep
no.
it under your custody.
Sorry, no, my lord, that can also be done.
Worship in that way, if there is a dispute, worship the state of Assam and Tamil Nadu, the nearest rehabilitation center is in Bangalore, Lordship.
Why?
Because
Who are you?
Worship, I am the intervener, Your Lordship.
So, intervener should be in, cannot go against the state.
No, we are not going against this.
No, you cannot go. You are not the writ petitioner. So therefore, we can't hear you on this.
This is for the welfare.
Millets, sir. Millets, if
Yeah.
you're not will,
You to help us.
We have no difficulty.
millets,
We agree with-
We direct
Let's-
you to
if your lordship will permit me, millets, may I make my
Yes.
submission, millets?
submit.
I am appearing for respondent number 11, millets.
Yes. What is your right to have the elephant beyond the period of 3 years or 6 years, which was transferred?
Very well.
What
Millets,
is your
first,
right?
yeah, I will just come to that straight away, millets. Before that, millets, may I just invite my learned friend, invite your lordship's attention to paragraph 10, millets. Would your lordships have a look at it again, millets? This deals with direct the central authorities shall forthwith report seizure of wild animals. At this point of time, this is not an animal in the wild. This elephant was a elephant with an ownership certificate lawfully transferred to the state of Tamil Nadu to be in the temple. So it's not a wild elephant.
No.
And abandoned.
Mr. Counsel, can you take one aspect? As of now, you don't have a right to continue to retain the elephant. Do you have any right?
Yes, millets. May I,
What is
millets,
your-
millets, as
what
far
is
as
your
your,
right?
millets, first,
No,
millets, as
show
far,
me, Mr. Counsel, show me what is your
just
right.
1
to-
minute, millets.
Yeah.
As far as your lordship's suggestion is concerned, that this matter be considered by the committee, I have no objection at all. The state government is also the same, state of Tamil Nadu is also the same, let it go before that, millets. Now, if it comes to the question of whether the state has the right to maintain this writ petition, I will make submissions on that if your lordship so please. And what rights I have also, I will make my submission, millets.
You mentioned about you submit as regards your third right.
Yes, millets.
Third-
My right, millets, even according to them, the elephant was given to me. Elephant is property. It is movable property. It was given to me for 3 years, validly given to me. I did not return it. I am at fault. Can a person who gave me the elephant for a period of 3 years recover it from me? Yes, it can recover, but within the period of limitation. Period of limitation is 3 years. If you don't recover that within that particular period, do not initiate any proceedings in respect of that. The limitation period expires. Section 27 of the Limitation Act, the right itself stands extinguished. I am not admitting the right of the state of Assam as to ownership. State of Assam never had ownership in respect of this animal. It is on Mr. Moraine who had the ownership of that. State has ownership in regard of animals in the wild. That Mr. Moraine, who was the owner, never initiated any proceedings. I don't want to go into all those things. Your lordship may refer to the committee, let it look into the welfare of the animal. Now, therefore, Miller, this right had been already lost by the time this writ petition was filed. in respect of a right which has already been lost. They cannot assert a right under Article 226 and claim that they are entitled to it. And they have come before your lordships claiming they have a fundamental right. What is a fundamental right in regard to property? Even an individual does not have. Has the state a fundamental right in regard to any property? It does not have. And what is asserted is the wildlife warden as a fundamental right in respect of that he can assert. He has no fundamental rights. The state or his functionaries cannot assert a fundamental right as against the citizen or someone else, much
We
against
refer to
another
the
state
HPC.
millets.
You seize the elephant, take it in your custody and keep it well, and then thereupon the HPC will pass directions and thereupon we'll take it up.
May you only indicate in it is not a captive elephant in that. This is an elephant in the temple. It is in the temple for many years. It is effectively worshipped as a deity. It participates in the rituals in the temple.
No, Mr. Counsel, the plea which you have taken doesn't seem to be an honest plea.
No, Miller, that is because your
No,
lordships
sorry.
asked me in law what is the position. That's why I
I'm
indicated.
entering
Otherwise,
into
I
it.
have no difficulty. I have no difficulty in regard to the committee looking into the matter and considering it.
You make all these submissions before the HPC, let the HPC consider.
Very well,
it.
Miller, your
But
lordship
in
will
the
leave it.
meantime,
All
the
contentions of
elephant
all
is
the
seized
parties
by
open.
you, kept in good care by you.
It is well kept in the temple, millets.
No, let the state of Tamil Nadu take it, because you see these.
Your lordship may
say-
indicate.
You
Your
see,
lordship
we are
may put
concerned,
it.
Mr. Counsel, we are concerned out here that the temple from here was taken to the state of Tamil Nadu with an assurance that it would be returned. And now you are raising the plea of limitation, means that you are trying to appropriate the elephant without having an ownership.
Your lordship asked me that question in law. What is the position? I answered that. Your lordship may only indicate if the state government feels that the temple should be taken into custody or the elephant is not being well looked after in the temple, then they may take it. Only your lordship may indicate it instead of a mandatory order. They shall permanently take it.
No. Tamil Nadu has given an assurance before the Madras High Court that they would protect the rights of their, let
Correct.
them protect it till it is not decided by the HPC. You fight it out also, go to the HPC and say that you have a right, let the HPC.
Very well, your lordship will leave it to the high-powered committee to take a view in the matter.
Yes. Mr. Naik, the learned counsel appearing on behalf, learned additional advocate general appearing on behalf of the state of Assam Union,
Say H. Gupta is there. Your Lordship.
and none appears on behalf of the respondent number 1. Mr. P.K. Tiwari appears on behalf of the respondent numbers 2, 3, and 4. You are appearing for respondent number 10 and 11?
I am appearing for 11 minutes.
Who is
10
10?
and 11. 11.
Lordship, we are the other intervener, Lordship. We are the other intervener, Lordship. We are PFC. People
Has he lost his voice? That the intervener for the respondent number 8 has to also intervene with his voice to make a submission. These interveners are absolutely incourageous, both of you.
past Lordship, all these things came on like your Lordship.
Why didn't you file a writ petition? Why didn't you file a PIL? Why didn't you go to the HPC? You have not. You have the habit of just approaching this court. This is not what has happened. Why didn't you file a writ petition? You could have been a writ petitioner. You have not. There are many cases which I see where PETA has come up and filed many writ proceedings.
Yes,
Why
Lordship,
haven't you come? Why you are intervening out here?
Lordship, the writ petition has already been filed.
You don't have a right before the HPC to make a submission.
Lordship,
It is
but in
only
other
the
cases,
respondent
Lordship,
by
we have been.
We
allowed
can't
to
help
file-
you. You have no business out there in PETA.
Lordship, we follow the Bombay High Court order. Your Lordship.
You follow, but in my directions, I make it clear that you have no business, both of you. So and so appears on behalf of the respondent number 8. So and so appears on behalf of the respondent number 9 and 10. And Mr. So and so, the learned senior counsel, assisted by Mr. Counsel, you are assisted by whom?
Mr. Otoli, Miss,
You are assisting
Mr. Otoli Kids Millets.
so and so for respond number 11. The present petition has been filed by the state of Assam along with its officials. Seeking directions upon the government of Tamil Nadu to respond to the request of the petitioners to cooperate, provide adequate security and facilitate the possession, return and transportation of the captivated elephant, Joymala, back to the state of Assam. The brief facts which led to the filing of the writ petition are that an elephant, is a female or male? A female elephant by the name of Joymala was owned by one Sri Girin Moran, who is the respondent number 7 in the writ proceedings. Said the respondent number 7 the purpose of transferring the elephant to the respondent number 11, Temple, sought for a no objection certificate from the Principal Chief Conservator of Forest, WL, and Chief Wildlife Warden, Assam. No objection certificate was granted on 26/8/2011 by the by the petitioner number 2, for transportation of the elephant to the respondent number 11 for engaging in religious activities. Now, where is the permission granted? Oh, no objection.
Page 24, Lordship.
This is not a no objection. This is the permission being sought for.
No objection for allowing entry to. No objection given by the Tamil Nadu government, Lordship.
No, this is not by Tamil Nadu. No. The petitioner number 2 was for permission from the respondent number 5, by the communication dated 26/8/2011, as to whether the elephant could be transported to the respondent number 11 temple for engaging in religious activities, for a proposed duration for staying in Tamil Nadu for 3 years. Pursuant thereto, the respondent number 5 issued a communication to the petitioner number 2, thereby providing the no objection
Page 25.
by the communication dated 8/9/2011 to transport the elephant, named Joymala, from Assam to the respondent number 11 temple.
Then page 31. Order of conservation. 15/10/2011.
Subsequent thereto, on 15/10/2011, the conservator of forest, East Assam Circle, Jorhat, had permitted the transportation of the temple of the elephant from Kakapathar under Kakapathar range of Dugdama division, Assam, to the respondent number 11 by a truck for its engagement in religious procession and ceremonies up to 17/9/2013. The records reveal that in pursuance thereto, the elephant, namely Joymala, was transported to the respondent number 11 Next. Though the period of the stay of the elephant was limited to 17/9/2013, neither the respondent number 7 nor the state government took any action. It was only in the year 2021 that the additional principal chief conservator of forest, wildlife and chief wildlife warden Assam had written a letter to the respondent number 5 requesting the return to Assam the elephant, namely Joymala, other captive elephants held at the respondent number 11 temple, and to provide rehabilitation to the elephant. It was categorically requested to facilitate the return of the captive elephants. And once the NOC is issued, steps would be taken to bring the elephants back to Assam.
I'm sorry, Lordship, just one line, Lordship, in paragraph page 33, Lordship. A condition was stipulated there that the ownership of the elephant will not be transferred under any circumstances while issuing the transfer certificate. Lord.
Subsequent thereto, on 15/7/2021, the Conservator of Forest Wildlife have again written a letter to the respondent number 5 requesting for return of the elephant and further intimating that on the basis of a communication issued by the respondent number 8 dated 1/6/2021, it came to light that brutality was caused to the elephant Joymala Full stop. The respondent number, the respondent number 5 thereupon issued a communication issued a no objection for transportation as many as 9 elephants, including the elephant Joymala, on 21/12/11/2021. It is relevant to take note of that in the said communication, in the said no objection, it was mentioned that these 9 elephants, in respect to these 9 elephants, the validity of the ownership certificate had expired and the captive elephants were being kept by temples and private persons beyond the transit period. Full stop. Subsequent thereto, by the communication dated 17/12/2021, the petitioner number 2 informed the respondent number 5 that a team from Assam State Zoo Division Gauhati with qualified and experienced veterinary doctor and assistants were being sent to Tamil Nadu to bring back the 9 elephants. It was further requested to seize and take custody of the elephants and kindly arrange to hand over the elephants to the team of Assam State Zoo Division Gauhati to bring them back to Assam. A letter of confirmation about the seizure and custody of the elephants by the respondent number 5 was sought. In reply to the said communication, the respondent number 5 informed the petitioner number 2 that the captive elephants may be seized and taken back by the arrangement of the Assam State Forest Department. And the officials from the Tamil Nadu State Forest Department would facilitate identification of the captive elephants, present location of the elephants and details of the present caretaker, etc. Also mentioned that if the Tamil Nadu Forest Department were to accept the request of seizure and take custody of the captive elephants, the cost of maintenance of the captive elephants from the time of seizure till handover of the captive elephants has to be borne by the Assam State Forest Department and to be paid before commencement of the seizure. In reply to the said communication, the petitioner number 2 again wrote to the respondent number 5 by the communication dated 25/2022 to kindly arrange seizure and take custody of the 9 elephants at an early date, and the cost of maintenance of the captive elephants till they are not handed over to the Assam Forest Department shall be borne by the petitioner number 2 as proposed. Further to that, an amount of rupees 5 lakhs was paid in advance 20 days, and the cost as per the actual estimate exceeding the amount shall also be borne by the petitioner number 2. It was also mentioned to provide the official account where the amount of rupees 5 lakhs could be transferred. So seen from the records that on 1/9/2022, a team was constituted by the petitioner number 2 who would visit the places where the captive elephants were held in Tamil Nadu and assess their health condition. A request was made by the petitioner number 2 to the respondent number 5 by communication dated 1/9/2022 to provide the necessary help to the team to visit all the locations and assess the health condition of the captive elephants in Tamil Nadu that were transported from Assam, and for paving way for return of the elephants to Assam. In addition to that, a request was also made by the Chief Secretary of the state of Assam to his counterpart in the state of Tamil Nadu by the communication dated 5/9/2022. It is the case of the petitioners herein that pursuant thereto, the respondents in the state of Tamil Nadu stopped providing the assistance so that the transportation of the 9 elephants, including the elephant Joymala, could be facilitated back to the state of Assam. It is under such circumstances the petition was filed. relevant to take note of. Affidavit filed by the respondent number 5 in the writ proceedings for and on behalf of the respondent number 2 to 6. It was mentioned that a writ petition was filed before the High Court of the Judicature at Madras 15/9/2022, which was registered and numbered as WPC number 25120/2022, wherein relief was sought for, thereby directing the government of Tamil Nadu to retain all the 9 temple elephants, including the Joymala, in their respective temples permanently, with further direction to the government of Tamil Nadu to take all measures in accordance with law for better upkeep, welfare and maintenance of the temple elephants in the state of Tamil Nadu. In the said writ proceedings, the state of Tamil Nadu, represented by its additional advocate general, on instructions submitted that the state of Tamil Nadu have no intention to send back the temple elephants to Assam, and that they are taking care of the temple elephants in the best possible manner. In view of the said submission, the writ petition was closed. Paragraph number 14 of the said affidavit, it was mentioned that a special health camp was conducted by the respondents in the Coimbatore district on 21/2/2021. And in the said health camp conducted by the Deputy Director Sri Vili Putur, Megamalai Tiger Reserve, Sri Vili Putur, it was further mentioned at paragraph number 14 of the said affidavit that on the allegation by the petitioner that the captive elephant Joymala was abused and ill-treated by its mahant in the special health camp conducted by the respondents in the Coimbatore district on so-and-so. An inquiry was conducted by the Deputy Director, Sri Viliputur Megamalai Tiger Reserve. Based on the inquiry, a wildlife offense was booked against the Mahut and Kavadi under Wildlife WLOR number 02/2021 in Metupalayam range of Coimbatore division. They were suspended from the job on the same day. Subsequently, their Mahant and the Kavadi were dismissed on 4/3/2021. It was further mentioned that the captive elephant, Joymala, is maintained by the respondent number 11 with a new mount and Kavedi. It was further mentioned that on 27/8/2022, a special committee was constituted to inspect and report on the maintenance and welfare of the above captive elephants as per the Tamil Nadu Captive Elephants Bracket Management and Maintenance Rules 2011. The report from the committee had clearly indicated that the elephants maintained by the temple authorities are in good condition.
My lord, only one addition till date. Medical team is regularly paying visit to the elephant. Medical checkups are being done, and periodically, that is once in 3 months, the medical reports are being prepared. We have already submitted the medical reports till below December 2024. And even thereafter, further medical reports are there. That we have not submitted, of course.
At this stage, it is relevant to take note of the stand which have been taken by the respondent number 8 by filing an affidavit. Wherein it is alleged that from the photographs of videos taken in October 2022, it is evident that the elephant Joymala was still being kept on concrete in chains. Deep wound marks on her legs were indicative of long-term chaining and likely torture, rope burns during training. Also mentioned that the pool allegedly constructed for Joymala is dry, which makes it clear that the Joymala is not bathed in it, but kept idle inside the shed for parked cars. Further to that, various communications which were the various communications which were issued to the Chief Minister of the state of Tamil Nadu by the respondent number 8 have been enclosed, thereby indicating the torture which has been committed upon the elephant, Joymala. Another additional affidavit was filed by the respondent number 8 on 18th of January 2024. It mentioned that various forms of torture still continues upon the elephant Joymala. The records also show that the respondents in the state of Tamil Nadu filed an additional affidavit on 27th of February 2026 whereby the periodical inspection reports of the elephant Joymala post 18/3/2025 were brought on record. Also mentioned that the state of Tamil Nadu conducts quarterly health inspection of the district level captive elephant welfare committee in relation to Joymala post. Has the respondent number 11 has filed any affidavit?
Respondent is not us. We didn't get any copy.
Mr. Senior Counsel, for the respondent number 11, have you filed any affidavit?
If you look at the page 245 perhaps minutes.
The month of September 2025.
And this is 392 lordship, starts from 392. Two affidavits they have filed, Lord.
July 2025, perhaps the pagination is to page 245 minutes.
In my one, it is written as page number is starts from 392.
Maybe perhaps if your lordship look at, maybe perhaps it is 345 minutes.
No, it is 392. Yes.
It's an affidavit dated
The
July
respondent
2025 minutes.
also filed an affidavit in opposition. Wherein it is stated that the elephant was gifted to the respondent number 11, and the respondent number 11 thereupon have been taking utmost good care of the elephant. It was further mentioned that an elephant is religiously essential in agamic temples as per the Hindu traditional practice and rituals. The elephant is highly revered and worshipped for getting blessings by the devotees. And the devotees are very much emotionally attached with the elephants in Tamil Nadu. The devotees in the state of Tamil Nadu therefore expect that temple elephants are properly maintained with love and care and utilized with great grandeur and splendor for the temple's pujas. It was further mentioned that it is a common practice in the state of Tamil Nadu that whenever a temple elephant expires due to old age, the devotees throng the temple and participate in funeral procession as if a family member of the devotee had died. The respondent number 11 further in details as to how the elephant in question, the elephant have been maintained. and where the elephant is kept. The food and nutrition which is being given to the elephant have also been mentioned. Apart from that, the healthcare checkups which are conducted in 15 days, every 15 days, have also been stated in the affidavit. It is further mentioned that the said elephant has been with the temple for the last 13 years. As on today, 14. And is sentimentally and emotionally attached with the temple. The respondent number 11, the respondent number 2, the petitioner number 2, though had submitted an affidavit in reply, wherein it is categorically mentioned that there is no question of gifting of the temple elephant to the respondent number 11 temple. Inasmuch as the same would be in violation of section 40 and 43(1) of the Wildlife Protection Act 1972. There is, however, no contest in the statements made by the respondent number 11 in their affidavit as regards the maintenance and upkeep of the elephant and including the bi-monthly medical checkups. In the backdrop of the above, the question which this court is required to, the question which arises for adjudication as to whether this court should direct the state of Tamil Nadu to hand over the elephant, namely Joymala, only one. What about the other 8? Not interested. Some sentimental reasons.
Right now, it's only Jamal.
No, there was a no objection given for 9. Why you are not on the others?
One gets settled, Lordship. Let the one get settled, Lordship.
But all these were given already. Did you get the remaining 8?
They given
This
session-
touches on your bona fides, Mr. Counsel. There are 9. No objection was given for you on 9.
Yes, Lord.
Then why you are only sticking to 1?
But Lordship, I mean, those paper, reportings were only in respect of Jaimala.
So are you saying to come up for paper reporting, you have come and file a writ petition?
That is not, initially so many complaints,
is
Lordship,
under-
on that was there. In other cases, that was not the situation, Lord. Allegations were not there in respect of the others.
The Lord put it simply,
So if
newspaper
it
report,
is the allegations, it is only for the well-being. You are therefore more concerned about the well-being.
One of the aspects, yes, Lord.
Well-being. It boils to that because if you are not taking for the remaining 9,
only Joymala is in picture simply because Joymala got the publicity. The other 8 did not get the requisite publicity, and newspaper reports are not there in respect of 8. That is why nobody is talking about
Why
that.
didn't you take up that issue with the newspaper?
Lordship, only because.
Must have been done at your behest.
Lordship, why, we are for the welfare of the animals. So we are not
Understood.
concerned
What
with
about the
anything.
remaining 8?
Lordship, we'll take care of them also.
Three
Lordship.
star.
We
You have
have-
not come up.
Lordship, we have been taking care of the Lordship in Kerala, in Maharashtra.
Well, this is
Lordship.
logged in.
What about the remaining 8?
बीच में पूछा था तब दिया फाइल
Torture, that's why you are not coming into intervene, your Lordship, because they are fine, Lordship.
Let me come back. The question which you write as to whether this court should pass appropriate directions upon the state of Tamil Nadu. For seizing the elephants which are seizing the elephant Joymala, which is in the custody of the respondent number 11, and then transporting the said elephant to the state of Assam.
Milord, can I just intervene? We also are praying for a Milord audience before the HPC Milord. There's already an order to that effect by the Bombay High Court Milord. Another proceeding, matter went to Supreme Court, should not said, okay, the hearing should go on.
I didn't get you.
Milord, and there was another petition, Milord, before the Bombay High Court where we intervened. And the matter was referred to HPC. There we made a prayer that we should also be given an audience by the HPC. That was permitted by the Bombay High Court. Matter traveled to Supreme Court. Supreme Court said hearing will take place. Can I pass on the order, Milord?
What did the Supreme Court say?
Supreme Court has said, Milord, let the directions issued by the High Court as contained in paragraph 11 referred to above be complied with at the earliest.
This paragraph 11.
Yes. Paragraph 11 to go. Paragraph 11 of the order in the main case. 1 second. Yes. Elephant shall be transferred to the respondent number 6. Radhe Krishna Temple Elephant Welfare Trust, Moti, Kavri, Jamnagar, Gujarat, within a period of 2 weeks from the date of uploading of this order. We request the Chief Wildlife Warden of Maharashtra to issue a transport permit and Chief Wildlife Warden of Gujarat to issue no objection certificate. If necessary to effect the said transfer, we also request the concerned police authorities to render support as sought for by the parties. Since, Milord, we have taken a lot of initiative, Milord, we are basically for welfare of the elephant, Milord. Therefore, Milord, we pray that we may be permitted either by video conference or physically as may be permissible, Milord.
What is this Radha Krishna Temple Elephant Trust?
It is a temple in Gujarat, Milord.
That is the same trust, Lordship, Reliance Foundation Trust, Anant Ambani Trust, Lordship. Same trust, every judgment's, Lordship, this is the only trust, Lordship.
Now what, no, here the elephant shall be transferred to respond number 6.
Hmm.
And the elephant is with whom? Don't step to sidely.
The elephant is still with the temple authority, Milord.
No. In
No,
this
no.
case,
Uh-huh.
in Bombay case,
Yes.
elephant was with whom?
The event intends to maintain its decision as seen in order. I think the Bombay High Court order was, Milord, if your lordship would kindly have the first para. The petition under the Article 226 of the Constitution challenges an order dated 27th of December 24 passed by the High Power Committee in relation to shifting of the elephant to so and so. In assailing the impugned order, Mr. Shah, learned senior advocate for the petitioner, drawing our attention to an order passed by the coordinate bench of this court in petition has submitted that petitioner was not heard by the High Power Committee in taking the decision to transfer petitioner's elephant to so and so.
Which
With
is
this-
the order you are referring to?
The order of the Bombay High Court, my lord, it's
Where I
dated-
got there are many. One is of
Malad,
2025 SCC online
was-
Bombay 267.
Swastisri, date is 28th of April 25. The lawsuits got it, my lord.
I am having the
28th of April
16
25
July
is,
2025.
yes. This petition under Article 220. Huh? আমার copy নাই নাকি extra? I think a copy was handed over by my learned friend Miller.
Yes, got it, got it. After that, the judgment has come, no?
Ah.
There is another judgment which has come.
Hmm.
This is of 24th of April.
28th,
Then,
28th of April, Miller.
28th of April.
Yes.
Then the main judgment has come.
Okay.
That is on an interim prayer.
Yeah,
is
this
the
was
main
on an
judgment.
interim application, our interim application.
Then the main judgment has come.
So here, my lord, we were permitted to take part in the HPC proceedings.
Where?
Para 8, my lord. We are informed that the next meeting of the HPC is now scheduled on 17th of May 25. Parties are accordingly permitted to appear before such committee either by video conference or otherwise as may be ordered by the HPC. Para 9. We find that the cause in the proceedings before the HPC was at the behest of the applicant. And in this view of the matter, we find it appropriate to permit intervention of the applicant. Accordingly, intervention application is allowed. Petitioner is directed to amend the application by including applicant as a party respondent.
Let the HPC consider that.
Yes, ma'am.
This court have also heard the learned counsels appearing on behalf of the parties. Mr. P. Nayak, the learned counsel's additional advocate general for the state of Assam, and Mr. K. Chaudhary, the learned senior counsel, appearing for the respondent number 8, had submitted that the elephant in question have been brutally tortured, and therefore there is a requirement for appropriate directions. It is the case of the state of Assam that the elephant be returned back to the state of Assam so that the elephant could be kept and maintained in proper condition. On the other hand, it is the case of the respondent number 8 that the elephant should be kept in a rehabilitation center specifically manned for elephants. In that regard, Mr. K. Chaudhary has referred to the rehabilitation center at Bangalore, isn't it, Mr.
Yes.
Name?
What is that name? We are giving the name right.
At Bangalore, and a rehabilitation station, namely so and so at Bangalore, wherein the elephant can be kept and maintained. On the other hand, it is the specific stand of the state of Tamil Nadu that though initially The state of Tamil Nadu gave the no objection. But taking into account the periodical checkups being carried out of the temple, of the elephants in the temples, and they are being maintained. A stand was taken by the state of Tamil Nadu before the Madras High Court that they would not be returning back the 9 elephants. Mr. So-and-so, the learned senior counsel who appears on behalf of the respondent number 11, submitted that the elephants are kept well, are well maintained. And they are also worshipped. The learned senior counsel further submitted, drawing reference to the affidavit in opposition, the elephants' daily nutrition, bi-monthly checkups, amenities have been provided. There's no denial to the same by the respondents in their affidavits about the facilities so provided for the upkeep of the elephant. This court, during the course of the hearing, inquired with the learned senior counsels appearing on behalf of the respondent number 11 as to what is the right of the respondent number 11 to retain the elephant, taking into account that the elephant was only transported to the state of Tamil Nadu for a period of 3 years. The learned senior counsel submitted that the elephant is a movable property. Such, the limitation for seeking the return is 3 years. And further, by virtue of Section 27 of the Limitation Act 1967, even the owner of the elephant cannot claim the return of the said elephant. This court at this stage finds it relevant to observe that there is a striking contrast to the stand taken by the respondent number 11 in its affidavit, inasmuch as it is the very stand of the respondent number 11 that the elephant was gifted. It is also the opinion of this court that the elephant cannot be considered to be is a living being. And the elephant cannot be considered to be a movable property, thereby to claim right on the basis of the period of limitation being over. The said submission made by the learned senior counsel opinion of this court that gives an impression as to whether the respondent number 11 is treating the elephant as a living being or a property. Be that as it may, from the from the stance which have been taken by the petitioner as well as the respondents, there is apparently that it is clear. It is clear that the elephant was transported to the state of Tamil Nadu for a period of 3 years. And the state of Tamil Nadu prior to 3/9/2022 duly acknowledged the fact that it was also the responsibility of the state of Tamil Nadu to return the elephant. Subsequently, in view of the stand so taken before the Madras High Court, the state of Tamil Nadu is not cooperating with the state of Assam for the purpose of transportation of the elephant in question. At this stage, it is very pertinent to observe that though the no objection was granted by the state of Tamil Nadu to the state of Assam for 9 elephants, but the state of Assam is only has filed the instant proceedings only for 1 elephant. Inquired, the learned additional advocate general submits that the steps are being taken by way of the present writ petition on the ground that the elephant have been tortured by the respondent number 11. Under such circumstances, the issue involved in the present proceedings is as to whether the elephant in question have been tortured by the respondent number 11. Conflicting stands have been taken by the petitioner, the respondent number 8, as well as the state of Tamil Nadu, as well as the respondent number 11. In this regard, this court now finds it relevant to take note of a judgment of the Madras High Court of the High Court of Tripura in the case of Srimati Sudeepa Nath versus Union of India, delivered on a judgment of the High Court of Tripura, the case of Sudeepa Nath versus Union of India, delivered on 7th of November 2022, whereby the learned division bench of the Tripura High Court had constituted a high power committee under the chairmanship of a former Supreme Court judge and appointed various persons by designation as members of the high power committee. amongst the members who are to be members of the HYPA committee were the Director General of Forest, bracket Union of India, number one. Number two, Head of Project Elephant Division, bracket MOEF, bracket closed. Number three, Member Secretary, bracket Central Zoo Authority of India. Number four, Chief Wildlife Warden, bracket State of Tripura, for elephants for the State of Tripura, semicolon. And number five, Chief Wildlife Warden, State of Gujarat. In the said, the Hyper Committee was entrusted to carry out various fact-finding inquiries, and make recommendations were to be made by the chairperson. And such recommendations would be enforced by the Chief Wildlife Warden. Further to that, directions were also issued that the jurisdictional police should also provide due assistance it is very relevant to take note of. That against the PIL, against the dismissal of a special leave petition, an application was filed by one Murli MS seeking clarifications pertaining to the directions from the state of Karnataka to restrict transfer, sale, gift, entrustment of wild and captive elephants within the state of Karnataka to private individuals, and in particular to the Radha Krishna Temple Elephant Welfare Trust. In proceedings, the Supreme Court took note of the judgment dated 7/11/2022 passed by the learned High Court of Tripura in the case of Sudeepa Nath Supra, and was of the opinion that a hyper committee which was constituted by the High Court of Tripura, learned High Court of Tripura, in the case of Sudeepa Nath Supra, the scope and jurisdiction of the said high power committee should be extended to pan India inasmuch as it would serve the real public interest and would advance the cause of welfare, care and rehabilitation of wild elements, and also would curb filing of frivolous PILs before different high courts by BGBs. The necessary changes. In doing so, the Supreme Court further observed that that there is a requirement of modification constitution of the High Pi Committee by the High Court, by the learned High Court of Tripura, to the extent that the chief wildlife wardens, bracket S, of the state bracket S, to which the issue relates will be co-opted as members of the state committee in place of the chief wildlife warden of Tripura and Gujarat throughout the territory of India, leaving it open to the high power committee to conduct necessary checks and to undertake fact-finding exercise in any pending or future complaint in that regard. The high power committee was also empowered to consider the request for approval, dispute, or grievance concerning transfer or import into India or procurement or welfare of wild animals by any rescue or rehabilitation center or zoo, by taking assistance and cooperation whenever needed from all departments and authorities across India. The Supreme Court further directed that all complaints in this regard be forwarded forthwith to the High Power Committee for consideration and recommendation appropriate, and for recommending appropriate action. In addition to that, the Supreme Court also observed that all state and central authorities shall forthwith report seizure of wild animals or abandonment of captive wild animals to the committee, and a committee shall be at liberty to recommend transfer of ownership of the captive animals or of seized wild animals to any willing rescue center or zoo for their immediate welfare, care, and rehabilitation. Paragraphs 8, 9, and 10 of the order passed in Murli MS Supra, which is reported in 2023 SCC Online SC 224, is reproduced hereunder. This court further finds it relevant to take note of that in another proceedings pertaining to Sudeepa Nath reported in 2022 SCC Online PRI 691. Huh. In another proceedings, which came up for consideration before the Supreme Court, in the context of the directions so passed by the Supreme Court by the learned Tripura High Court in High Court of Tripura, in the case of Sudeepa Nath Supra, the Supreme Court, on an application filed by one Prerna Singh Bindra and others, by an order dated 12/5/2023, that the scope of the jurisdiction of the HPC should be further enlarged to look into the aspects pertaining to number one, duration of ownership certificates in relation to elephants, semicolon. Number two, inquiring into the capacity of the facility where the elephants are proposed to be transferred, semicolon. Number three, monitoring of the health and age of the elephants. Number four, monitoring the facilities for transportation, semicolon, and the need to shift the elephants. It was also the opinion of the Supreme Court in the said order passed on 12/5/2023 the chairperson of the HIPAA committee, Supreme Court further observed that the chairperson of the HIPAA committee the Supreme Court further directed that the chairperson of the HIPAA committee is permitted to co-opt an expert specifically in the area of rehabilitation and care of elephants. It was also the observation of the Supreme Court in the said order that the remit of the HPC would comprehensively cover all aspects, including those which are sought to be raised on behalf of the applicants in the said application. Or in other words, all relevant aspects are entrusted to the decision-making process of the HPC. In the backdrop of the above, if this court takes note of the respective submissions which primarily relate to as to whether the elephant, namely Joymala, is required to be transported back to the state of Assam, the rehabilitation of the elephant, semicolon, the monitoring of the health and the facilities provided to the elephant, etc., come within the ambit of the High Park Committee.
Including the need to shift the elephant. That is also there, my lord. Rirna Singh Mindra. Need to shift the elephant.
First line to go, sir. As to whether it is required to be shifted back to the state of Assam, would it not encompass?
Oh, yes, my lord. I'm
Then-
sorry. Yes, yes. Let's do it. Let me-
Would come within the scope and ambit of the HPC, High Pay Committee. It is also the opinion of this court that as to whether the respondent number 11 have been maintaining the elephant in a proper condition can also be looked into by the HPC, taking into account the committee would comprise of not only chief wildlife wardens of the state of Assam and the state of Tamil Nadu in the present dispute, but also the member secretary of the Central Zoo Authority of India and the head of Project Elephant Division of the Ministry of Environment and Forest. Additionally, the committee can further, the chairperson of the committee can further co-opt any expert specifically in the area of rehabilitation to look into the said aspect. Considering the above, it is therefore the opinion of this court that the dispute involved in the instant proceedings should be referred to the High Park Committee for carrying out the fact-finding exercise including the question as to whether the respondent number 11 can claim ownership over the elephants in accordance with law.
Lordship, that issue, Lordship, as regard ownership, may not better to leave to the High Powered Committee, Lordships. They are
Right.
not, I mean, how come they decide the issue of ownership of the elephant, Lordship? Lordship, that may not be left to them, Lordship. Ownership is already decided, Lordship. So far as the issues regarding ownership, illegal captivity, these issues are already on record, Lordship. That has been admitted by the state of Tamil Nadu also. So that issue may not be kept open, Lordship.
I'm not him. I'm only saying his respondent number 11's claim of ownership,
No.
not yours. Let him say, because his right to maintain is on the basis of ownership. Otherwise, if he doesn't have, immediately it has to be shifted to you.
No, as it appears, Lordship, High Court Committee is not considering the legal issues, Lordship. My submission, Lordship.
Let it be there.
So that may not be, I mean,
I'm also exercising 2 to 6. Whether the Tripura High Court didn't exercise 2 to 6.
no, even Tripura High
I'm
Court,
saying, didn't the Tripura High Court exercise 2 to 6? The Supreme Court is exercising 136. I also have the power under 2 to 6.
no,
And
my-
you need not dictate me what is
no,
to be
no,
done.
my submission is very
Take
limited.
your seat,
Lordship, yeah.
whatever it is. Go and file an appeal before the division bench. This is my order. Accordingly, this court, therefore, refers the dispute refer the dispute of all 9 elephants.
Whatever.
This court also takes note of that apart from the elephant in question, Joymala, there are 8 other elephants who are in the state of who have been transported to the state of Tamil Nadu. And are being either privately kept or maintained by the temples. In aspect would be apparent from the NOC issued by the respondent number 5 to the petitioner number 2, dated 12/11/2021. It is the opinion of this court that the reference that the legality and the legality of the transportation as well as the permissibility to retain the elephants beyond the period of the NOC so granted by the state of Assam is also required to be looked into by the HPC in respect to all the 9 elephants, including the elephant Joymala. Accordingly, the writ petition accordingly, this court passes the following directions. In the instant proceedings, in respect to the elephant Joymala, along with the other 8 elephants the details of which are provided in the no objection certificate issued by the respondent number 5 to the respondent number petitioner number 2 bearing no objection number bearing communication number WL1/24545/2019-1 dated 12/1/11/2021 is referred to the High Power Committee to decide on the following issues. Points of reference. A, whether the state of Tamil Nadu can deny the transportation of the elephants, of the 9 elephants, including the elephant Joymala, from the state of Tamil Nadu to the state of Assam after the period of the no objection after the period had expired, and more particularly when the no objection certificate have already been issued. Number 2, inquiry into the capacity, into the facility where the 9 elephants, including Joymala, are being kept. Number 2. Inquire into, number 3, inquire into the maintenance and upkeep of the 9 elephants, including the elephant Joymala. Number 4. The necessity of transportation of the elephants from the state of Tamil Nadu to the state of Assam. Next. In addition to the above, it is the opinion of the parties to the instant proceedings would be at liberty to raise such further or other issues before the High Power Committee as regards the 9 elephants in question. List this matter on a copy of this order, be it, who will give the copy? HPC.
Someone has already referred or will refer.
Last in Tripura High Court's order, Lordship, Tripura High Court's order, just mentioned a copy of this order shall be forwarded by the registry to the Honorable Sri Justice Deepak Verma, Lordship.
Understood, but that the court constituted. Now there is a High Power Committee.
There is. This function.
A copy of this order be communicated to the chairperson of the High Power Committee. Where is the address?
Address will not, I'll have to find out. I have no idea.
Intervener.
We will provide your lordship in 5 minutes. We'll provide.
Now you provide it to them. Just find it. I think you can find it in the net. You can, yeah. Yes, so and so. By the registry and so and so. In addition to that, the parties are also granted the liberty to provide a copy of this order to the High Power Committee. This court leaves it open to the chairperson of the High Power Committee to determine the honorarium and the expenses required to carry out the functions, which shall be borne by the concerned states, that is the state of Tamil Nadu as well as the state of Assam, as the case may be. List this matter upon the report of the High Power Committee, upon the report oblique recommendations made by the High Power Committee.
Lordship, a timeline may be fixed for the High Power Committee, Lordship. Can it be done, Lordship?
That considering not.
Another line I put it, huh? This court also directs the state of Tamil Nadu to carry out necessary inspections in the facilities wherein the 9 elephants are being kept. And in the circumstance, it is found that any of these 9 elephants are not kept properly by providing the nutrition, medical facilities, as well as facilities. The elephants, the concerned elephant, be seized by the state of Tamil Nadu and maintained by where?
In a state facility, Lordship.
State facility centers are there, my lord.
You just find and give it.
Whatever, sure.
In the state facility, you find out where is it. Not in Bangalore.
Not in Karnataka.
No, in
No,
Tamil
In the
Nadu.
state of Tamil
State
Nadu
of
also.
Tamil Nadu.
They
Because
have.
the rehabilitation center that I'm talking about, lordship, those are.
That's in
all
Bangalore.
large X-ray machines are also there, lordship. It's a-
Understood, but you see, there again, it is a transfer from,
difficult.
there is a transfer, this is an
Yes.
interim. This is a transfer, that means it is a transfer from Tamil Nadu to Karnataka, which it became another aspect. In India, so and so, he will give it. Full stop. It is further observed that the above is an interim direction and the High Power Committee shall pass appropriate directions upon being seized with the present proceedings.
But in the participation,
All the parties
Approach.
not appeared. What is your submission? What is your submission? Whom are you supporting? Tell me. Whom are you supporting? Tell me. Then we'll pass on. Tell me. No, you can't. You cannot just jump out and say out here that whatever it is. Mr. Senior Advocate, you will keep it with you, but they will make inspection, and if it is found that the elephant is not in good condition, then they will take it.
Of course, millions. The state is satisfied it is not well maintained. Your lordships are absolutely right.
Yeah, so that is what I passed that order.
Yes, yes.
And next thing is, what is your submission? Whom are you supporting? The Hyper committee is not a party here. Whom are you supporting? Are you supporting the state of Assam? Are you supporting the state of Tamil Nadu? Are you supporting PETA, or are you supporting respond number 11? Tell me. Make only that submission. Whom? Not come up and say that I appear for so and so. That means you don't know anything. Whom do you support? It's Gupta for respond number. Where is the government? Yes.
The instructions I had passed over the earlier occasion, they have prepared an affidavit and they have sent it. It's in transit. What a scan copy.
So your stand remains as per the instruction.
Is as per the instructions, Lordship. But I have not yet filed it, Lordship, because the hard copies.
The file is no.
No, I have not received the hard copy, Lordship. This is in transit.
Okay.
It's the same thing, Lordship.
Yes, Mr. Nath, because of you, we couldn't finish it on the last occasion.
Lordship, I am appearing for the Omyo Kumar Das Institute and for the ICSSR. For if Lordship kindly takes up the affidavit filed by the respondent number 5, 6, and 7, Lord. Just kindly take up the affidavit filed filed by the respondent number 5, 6, and 7. It starts at page 218, Malon. In fact, what we have said, Malon, para 4, Malon.
Yeah, we want to finish file it now.
Two 218, it starts. Paragraph 4 starts at page 219. Lordship may kindly come to para 4. So we have stated that the starting portion can be we have stated that the Indian Council of Social Science Researches, ICSSR, it was established in the year 1969 by the Government of India to promote research in social science in the country. ICSSR provides grants for of projects fellowship, and under the ICSSR, this Omyo Kumar Das Institute of Social Science was established in the year 1989. The second paragraph is important for us, Malad. We have stated that the institute is sponsored by the Government of Assam and the Indian Council of Social Science. Thus, the Omyo Kumar Das Institute is a registered society under the Society Registration Act. The aims and objectives of for which the institute is established is to undertake, aid, promote, and coordinate research on problems and process of social transformation and development of Assam and other states of northeastern region, and to contribute to the formulation of strategies and programs for speedier regional development, to provide academic and professional guidance to agencies, institutions, and scholars engaged in research in social sciences and development, to offer on request advisory and consultancy services. Malad.
Come to the point,
Malad. Lordship.
age 60.
Malad.
Come to the point as regards age 60.
60.
Yes.
But before that, Malad, I'll just like to take your lordship to the memorandum of.
Not there on the earlier occasion.
Malad,
Make it big.
I'll take your lordship to that only. Malad.
No, what has happened in the
Lordship.
You have a particular regulation
Hello.
wherein you have put the age as 60 big and oblique, or as what the government decides.
Notified.
Now the government cannot decide alone. The state has to take the concurrence of the central government.
Malad.
As of now, the central government have not been provided a proposal.
True.
By you.
True.
On the other hand, you have given a proposal against enhancing. So the central government, having not provided the approval, which is the requirement of the pay, is in terms with 2011 notice issued by the central government, can the court direct you, and thereupon you make an enhancement of the age, submit it to the central government, and then also direct the central government to make it 65? The issue. Very small.
True.
Although many have filed many affidavits. My question is this limited. Only issue out here is whether the petitioner, being a professor, the petitioner's age should be 65, taking into account that in respect of professors, you have made 65 for medical institutions or educational institutions. You have made it 65, not you, the government has
The government.
made it.
It is a state decision.
So the government has made it. Now a question arose before another coordinate bench. Why not the assistant professors should be given the age of 65? The coordinate bench said that in respect to the taking into account the cabinet memorandum for enhancing the 65 for the of the professors of the educational institution is on account of their lack of availability of professors in that educational institute. This is a research institute. Therefore, the state have considered this to be a research institute, have always differentiated with an education institute.
Education. Lordship.
It made the petitioners tried to make out a case that look here, whatever may be, the research institute is also a part of an educational institute, or you can very well say that is also an education, because without a research, there cannot be a proper educational institute. So it being a part of it, the same principles should apply. These are very good aspects. But the main problem arises is whether the central government Central government having not approved, can the petitioner, on the basis of you, even if you say tomorrow 65, and apply to the research institute also, can the petitioner get it? No, without the approval of the central government.
No.
I don't-
In fact, what I am trying to point out before your lordship, the memorandum of association of the society, we have annexed, annexure 1 and annexure 2. Well, in annexure 2, if lordship kindly comes to page 255, the memorandum says governing body is the highest body in the society, well, in the institute. And in fact, if lordship kindly come to page 255, it starts at 255. This is the memorandum of association. The relevant lordship rule 17 at page 273, my lord. It provides for the rule 17 provides for faculty. The faculty includes, my lord, the faculty of the institute shall consist of all professors, honorary professor, associate professor, assistant professor, fellow, and visiting faculty. And lordship rule 25 provides for amendment. If lordship kindly comes to rule 25 at 276, amendment subject to the provisions of the Societies Registration Act 1860, the institute may amend, add, or delete any of these rules by a resolution passed at a special meeting of the governing body, duly convened for the purpose and supported by 3/5 of its members. Such amendment shall take effect only after they have received the approval of the Indian Council of Social Science Research, the Government of India, and the State Government of Assam. So approval of all three are required for amendment.
Amendment of
Rule 25, 276, my lord.
the amendment of this
Amendment of
memorandum of understanding.
memorandum of rules. My lord, but in fact, the rules, this memorandum of association, my lord, provides.
Does that have any relevance? See, this, in fact, you have made it wrongly. The amendment should have been in respect to the amendment of the memorandum of association. Don't bring this unnecessary, this is unnecessary, because in these, when you have not framed the rules, where is the question of rules? The rules will be, have been framed separately.
This is
The
this
rules
is a,
will be made. Where is the rules?
the regulation. Whatever the
Where is
regulation,
the regulation?
the service regulation of 2022. That lordship in the writ petition, lordship will find.
H.
It starts at page 164.
164.
At the
These are the regulations.
yes, my lord.
Faculty of Regulations 2022.
Lordship.
We call the Omeo so and so. State government. And here we are concerned with case of
32, my lord.
32.
32.
Of super of all faculty and share of the AI is the full time is 60 years, public as notified by the government from time to time. Now the government have not notified.
The government has not notified. In fact,
So therefore, what is the petitioner asking?
there is a process, my lord, that the Amiya Kumar Das Institute in its meeting, in the governing body meeting, because the memorandum says the governing body is the highest body in the institute. The governing body in its meeting has resolved to enhance the age. It was communicated, it was placed before the government. Government has turned down. In fact, the order by which the government has rejected, that is impugned in this writ petition. and therefore, my lord, while referring to the memorandum of association, lordship will find that the governing body, the power of the chairman, and all faculty members and everything has been governed by this memorandum of association. So the amending power is there in under Rule 25 of the memorandum. It says that if in case of any rule is to be amended, then the approval of all three has to be taken. So therefore, it was placed before the government.
But Mr. Very difficult for this to accept your submission because this is as this memorandum of association in the rules of so and so. You have to understand that this is the rules.
The society, my lord, society can
Understood.
frame
So
its
this is
bylaws.
rules.
Society can frame its bylaws, my lord.
Understood.
Lordship.
Society rules
Lordship.
are to, if you amendment has to be made, it has to be amended by you, then by government, then by the ISSCR. These three are there. But this is in reference to this memorandum of association. It has no relevance to the regulation. You see, kindly see page 255. What is
But
the name of this?
it is the memorandum of association and rule of the institute, my lord.
Yes. So this is the rule. If you want an amendment, you do it. Now these rules do not say anywhere what is the age.
No.
Does not say.
No.
Neither these rules say anything as regards the terms and conditions of the people who are working.
Well,
Doesn't. For that, you have a different regulations, which is of the regulations of 2022.
Lordship.
Therefore, that it is necessary or not is not springs from there. The power that it is required is because it is an aided institution of both the central government and the state government. So when you do it, you have to take the concurrence. Otherwise, who is going to fund it? So therefore, the ISSR have, or the Ministry of Education or the Human Resources at that point of time, had categorically mentioned that you cannot change the terms and conditions without our approval.
That's true.
We are paying you. So without that approval, now here the approval has to be meted out through the government. The state has to give the proposal. Now the state have always rejected it, and therefore the question has not gone even to the central government.
Central government.
This is the way.
That is lordship.
So the moment if I write anything out there, wouldn't it the people laugh out there? Then look here, the judge doesn't know the meaning difference between the regulation and the rules. Me, I don't think that submission. Make a submission which is this court will accept. Just for the sake of it, don't make it. Otherwise, if I put it tomorrow, you will also go out there and laugh. What is the court have understood?
My respectful submission is, my lord, power of the governing body and the authority who is for making the regulation and all, it is given in the memorandum of association, and that is the my lord, the power to the governing body for making the rules and regulations comes from that only. Therefore, ultimately, my lord, therefore, while they have taken a decision in the governing body meeting that they have they initiated a proposal for enhancement of age, it was moved to the government. Ultimately, lordship we have annexed. The response of the government is there, my lord. If lordship kindly comes to page 296. Because it was the resolution of the governing body only, and the governing body is the highest body of the institute. 296 annexure 11, lordship will find. Secretary, Planning and Development Department has written to the director that in inviting reference to your letter, this is to inform you that after careful consideration of your proposal and resolution in the 52nd meeting of the governing body of the institute, as well as special meeting of the governing body held on 22nd of August 2014, the government of Assam in the Planning and Development Department has following views. The second is relevant, my lord. Number 2, the matter relating to retirement age of faculty member and other staff of the institute has been considered in detail. After careful consideration of retirement age of the employees of Government of Assam, other institutes established by Government of Assam, UGC circular, Supreme Court verdict, etc. On the subject, it is felt that the retirement of both faculty members and other staff of institute should remain 60 years of age. They informed in that manner, ultimately thereafter, page 298, Lordship will find the transformation department, they have, my lord, forwarded a copy at 298, Lordship will find.
Okay, done.
Hello.
Mr. Yeah, what do you want to say?
ICSSR, my lord, the other respondent for whom I am appearing, they have a similar stand, my lord. Ultimately, it is up to it is for the state government, my lord.
See, Mr. Nath, if you bring, you are not considering the petitioner today. He's already 64.
Yes, sir. 62. Retired. Completed 62 years, 63.
Because yet only a year. For me to bring all these aspects pertaining to the rule which we are mentioning, tomorrow, if the moment you get independent, for good luck, there is something out there, you get independent. Then also you will be stuck with that rules if you make that submission. One can very well take away or get your relief without disturbing the presence or anything being recorded. That is a better sort. You are an institute. For Mr. Sutia to say that the government is going to do is different aspect. You may say, Mr. Architect Chaudhary may say, may very well say. But don't you bring your institute in that? Because your stand all along have been that it should be 65, then only we can attract good people. That's your resolution all along. So the managing committee, who is the head, who is the highest authority, have always requested that kindly increase it. Government have not done it. Now, government has good reasons or not is another aspect which needs to be looked into. The government has stated out there two things. Earlier in 2012, said that we don't want to do it, which was reported in the year 2014, communication which he had challenged. The second is in the year 2019 or 20, again the government took into account pursuant to the government's cabinet resolution in require the medical colleges and educational institution and says that research institute would not come within the ambit. And then on the basis of that, the 2022 communication was issued, which is being subject matter of challenge. So the government has a reason. They have put a differentiator out here as to whether the educational institution and medical institutions are different from research institutes. And therefore, we don't want to do. But be that as it may, the main problem arises is not with the government also. Unless the government makes the proposal to them and they don't approve, the petitioner cannot. Now, the rules have been made out there as the government decides. Now, the government can be scored, therefore, direct the government to decide in a particular manner. Very difficult. Let's hear Mr. Sukia.
That's
I've
my
heard
lord,
you-
my lord, limited submission is there, my lord. The informal item number 1, that is the proposal, that is the order of the government, my lord, the chief minister passed this order, is very clear cut, my lord. Raising of retirement age 65, it was decided to raise the age of retirement of all professors of educational institutions, including medical college, to 65 years. There is no exception, my lord. So if there is no exceptions, the petitioner claim cannot be considered because this institution is not covered under the educational institution. So educational institution and medical college specifically say this is ballot, education department and health and family welfare department, only 2 departments. So the petitioner's institution is a malot research institution. My lordship, kindly see our affidavit, additional affidavit, page 436.
I've read it.
I read it, yes.
No, I have read it.
Let's read it.
Anything else, Mr. Sukia?
That is the malot, the Deputy Secretary of Government of India.
No, no, I've read it.
This letter says that those who were in the teaching position they are only entitled. That is the education institution. The research institution is, what happened? They have an agreement with the Dibrugarh University. Dibrugarh University agreement said, Dibrugarh University, you are the research institution, and you are with our agreement that our research scholar will be sent to you, and you will accept it according to your guiding. They are in a guiding position. They are not in a teaching position. That's why, my lord, this resolution raising the age of 65 is a clear cut. There is no any exception, and there is cannot be covered. And other in all India basis, 24 institution is there. Lordship has gone it, my lord. 24 institutions, all of the states, my lord, they have a different age of retirement. Somebody in suppose Kerala 62, some 60, some 65, like that. In government 60. The government till today, Lordship has pointed out, Malad, there is a coordination is necessary because the government till today has not adopted any resolution or any decision to raising the Malad retirement age 65 to the other institution. If it is Malad allowed this institution, government says,
Now tell me why the government's resolution is required?
Malad,
Why the government's resolution is required?
Malad, because the government they are governed by the managing committee. Their own regulation and rules is there. They are governed by them. Not the Gauhati University Act is there. Gauhati University is like the theatre. Dibrugarh University Act is there. Dibrugarh University colleges are governed by the Dibrugarh University Act. And now, my lord, this institution is separate institution, my lord. Under Gauhati University and under the Dibrugarh University, Tezpur University, there is also facility for research. They are not only that they are the research institution, and all research scholars should be go to their institution. It is not a there, and they are not there. They are not giving any certificate, diploma course. They cannot issue it. They only guide the research scholar. So
No, you see,
government
no, Dibrugarh University or the Gauhati University is under a legislation of the state.
state
So that is another aspect.
aspect
Here, the petitioners institute is a society.
society.
If it is a society being granted aid from the state and the center, this is how it is being regulated. This is being provided.
Yes.
So it is not a society, or it's not not an institution in which is set up by way of a legislature. So there is a difference from Gauhati University and Dibrugarh University.
That's why, Ballot, government alone cannot take the decision. The ICAS ballot is there, and they are funding 45%. We are funding 45%. They are only funding 10%. So we have a control over it. So they cannot alone by the governing body take a decision that our age of retirement should be professor 65 years. They cannot take it. It is not approved. And the central government, I have not got through all these things. Arkade is produced it, my lord. The central government is denied it because they are not entitled. So state government also, my lord, like other 24 institutions, including this institution, my lord, they are different age of retirement. So the petitioner's claim for age of retirement to 65 is not tenable, madam. That is my assumption. And our this resolution is clear cut, madam.
My lord, the basis of
Obliged.
the basis of denial is that the institute is not an educational institute, it's a research institute. And whether the question raised in the writ petition is whether that classification is a reasonable classification, my lord. In respectful submission of the petitioner, my lord, this classification cannot be said to be a reasonable classification because to being a professor under the regulations as well as UGC regulations, the criteria are exactly same. Everything is same, my lord, except the age of superannuation. And in fact, all 24 institutes follow the retirement age of the respective state universities. That has been the consistent case of the institute since its 52nd board meeting. And the differentiate they are trying to make that education and research are two distinct and separate is against the constitutional scheme. My lord, if lordship goes to entry 66 of the list 1, there, my lord, education and research are placed together, my lord.
No, Mr. Counsel, the aspect is this. A researcher
Mm.
If he is there in the Gauhati University or in the Dibrugarh University, he may be considered differently.
Yes.
But you are in a society.
Yes.
So if you are in a society, can th- can you be treated separately?
No, but I'm not.
One,
Yeah.
that is one. You cannot be equated with a researcher under the Dibrugarh University or the Gauhati University because these are under the legislative acts. Number two, more pertinently is, can this court direct the state to increase the age of a researcher who is a professor to that of 65?
No, my lord, I'm responding to the second query first, my lord. Lordship rightly has pointed out that whether this court can direct, but if the reason for not giving the age is found to be discriminatory, my lord, then Lordship definitely can set aside that and remand the matter.
Obviously, there is a fundamental distinction between you in an institute which is set up by a society with with a researcher who is a professor coming before the Dibrugarh University.
Yes.
There's a fundamental distinction. So there is a differential. There's an intelligible differential on that.
People from
Now, if they say to that effect, now they have this institute, which is a society, they are saying that make it 65, then we can get good people. That's the basic idea on which it is being done. But the fact remains that you cannot be equated with a job which is there under the Dibrugarh or the Gauhati University or any other university which is being set up on by way of a legislative.
that cannot be made. But people from this institute can go on deputation and to universities. People from universities earlier used to come to this institute on deputation and got permanently absorbed here. But due to this uncertainty of age, now, my lord, lots of posts of professors are being lying vacant. That is my instruction, my lord. Earlier, people from
If their posts are lying vacant, if both the central government and the state government, they do not want this institute, they may not like the institute.
that may
Is it for this court to look into that? You see, that must have been the reason why they are not giving any importance. But for this, should this court take an attempt to revive at your behest if the state government and the central government do not want?
No, my lord, the issue is whether the rejection is, the ground cited for rejection is reasonable, my lord. If lordship comes to,
It is reasonable because you are in institute, you are just an institute formed as a society. You are different from a legislative. If you are a researcher under the earth, therefore I say even a researcher may get it. The same, it may be a part of the educational institution. But can you claim on the basis of a society? Question is there. Can you claim on the basis of a society? That is the main problem. which I
But-
see.
claim in the sense, my lord, in fact, my lord, this institute, specifically, my lord, I have stated in paragraph 16 and 17, earlier two professors continued beyond 60 years of age. And that has been admitted by the institute in their affidavit. But state has not responded to that, my lord. This is not a case that if that can be done in respect of two professors, that has been done, my lord. Lordship, kindly turn to paragraph 16 of the writ petition, my lord.
No, as of now, the regulations of 2022
Yes,
makes it clear it is 60 or as decided by the government.
yes.
Now, you are regulated by those regulations.
Yes.
So as of there, the state government says that no, in respect to this, we keep it at 60.
Yes.
You say that there is no proper rational nexus or there is no reasonable classification. As much as I am also a researcher, researcher who has the tendency of a professor, and where is also there are other researchers, not researchers, the professors who are in medical or educational institutions who are getting. There is a fundamental distinction between your setup and alia. Yes, if you were from the Dibrugarh University, I would have looked into that aspect. If
Yes.
that was the thing where an educational word for a professor or researcher out there, there might would have been a case to that effect. But taking into account that, see your existence of an institute, You are just a society and you are maintained as a society.
Yes, but society, although it is.
Problem lies
Yes.
there. See your existence. They should have, either the government should have thought about it. It has been going on from 1989. It's around how much? 37 years. 37-year-old institute. They should have thought about it. Then look it. We make it a legislative, an institute under the legislation. Just for example, we have the Naluja. Naluja is based upon a legislative act.
Yes.
So therefore, their professor out there, he may be a researcher also. He may very well claim that I'm entitled to 65. Or because of the fact that those people are given 65 for educational institution. I may be a researcher, but then also, that's a different thing. But for you, see your entity to your existence. And you are in a grant in aid school institution where it cannot be directly given. First, the state has to approve. The state has to notify. And once the state does it, even if the state government does it, the central also have to do it.
Yes.
And without the center doing, nothing can happen.
Yes, that stage has not yet come because state government has rejected. So if the rejection of state government, if I can submit this way, my lord, if lordship say,
Show me one judgment wherein the court had directed increase of age.
no, but I am not directly on the increase of age. I am.
This is the most fundamental on the point. Can the court direct the increase in age? That yes, the age should be such.
But
you have to put the high the core the institute in such a pedestal that yes, increase of age of 65 is necessary. But because it is absolutely the domain of the government.
Yes, ma'am. I understand that.
This way or that way, it boils down to the same point.
Yes.
Can the court direct them to consider, make it, or direct them to not consider, make it 65?
Well, if that cannot be done, my lord, I am not saying that. My respectful submission is that if the ground for rejection is taken into consideration, that if that is, my lordship comes to a conclusion that that classification is not a reasonable classification, let them take a fresh call on if they have some other materials to show that for these reasons the institute will not get. There need to have been a different case, my lord. Their affidavit, their submissions, everything boils to one point that there is a distinction between education and research. And I have
there. For your purpose, you are in institute, which is born out of a society. Kindly see page 290.
it's annexed with the writ petition also.
Whether or not so-and-so qualifies as an educational should be ideally indicated in the initial resolution or the MOU where the institute was established. As per the aims and objective of AI, it appears that the institute is specifically established for research and training. Education is not mentioned. This is what they are saying.
Yeah, this is the view of the education department. The transformation department sought opinion. And other way, there is another way of looking at it. Just because education department does not consider it to be an educational institute, can the transformation department say because education department doesn't consider you to be an educational institute?
Does the transformation department say that it is required?
My lord?
Does the transformation department say that it is required?
They have brought that communication has been brought on record, my lord.
No, your communication that the transformation department accepts the education department's observation.
The education department merely said the administrative department will take a call. And they have taken, last part, my lord. Last paragraph. In view of the above, the administrative department concerned may perhaps take final call on whether or not so-and-so is to be considered an educational institution for increasing the retirement age of professors up to 65 years.
Understood. So then they have taken the decision at page 300.
Yes.
Not to increase.
Not to increase.
So and not to increase when they have taken a decision. My question is, can this court direct to increase?
No, my lord, I am not directly saying to increase. If lordship considers that the classification is not reasonable, then matter may be remanded back to them for a fresh consideration by if they take a fresh decision without differentiating it to be an educational institution and research institution.
But the fundamental point lies, which is you are a research institute, you are a society.
But society 100% governed deep and pervasive.
But you are a society.
Yes, my lord.
So,
But
for a society out there, you are given the amenities is okay, but you are a society after all.
I am a society under Societies Registration Act. And university is also an act of legislature.
No,
I am the.
oh no, there's a difference.
Yes, there is a difference, my lord.
There's
I am not.
major difference.
I am not saying, my lord, this is exactly same. But the thing is
Not
that
exactly. One is there, one is here. Very difficult. Show me where the court can direct.
my
The
lord,
only problem.
yes, that I
Because
have
you
not.
see, I am asking them for consideration for what? Why should I ask them for consideration? If at the end of the day, my consideration will be a request to them. The consideration of them has to be on the basis of a legitimate. You have a foundational right for being given 65. And this 65 and this court can very well ask them to look into it. But can I say that you have a foundational right of being 65?
No, my lord, that
More particularly taking into account that the prerogative is absolutely of the state as it is your regulation. But
regulation.
because you have not challenged the regulation 32.
No, I am not challenging regulation, my lordship. Kindly.
Understood. Your thing is, and what the government may decide.
Yes.
So you therefore say, and what the government may decide, the government should decide that
No, my
it
lord.
should be 65.
No, my lord. My interpretation is that government has already decided by means of page 78 that it will be 65. That is
Where?
the government as notified by government.
But they only say about educational and medical colleges.
That is where, my lord, this institute.
And in fact, what the transformation educational department or the government is now doing is, they are giving a clarification that this is nothing to do with research. This is more of a clarification. They say that we are only restricting to medical colleges and here.
But whether that is reasonable, my lord. And if your lordship kindly turns to page 80 of the same regulations, my lord. Regulation 40 says interpretation. If any question arises as to the interpretation or application of any of the provisions of these rules, the decision of the governing body shall be final. If they are relying on first part of regulation 32, that it will be 60 years, then they cannot shy away from regulation 40, which says decision of the governing.
No. They are not. They are saying it is 60 or the government may decide. Now they, in terms with that interpretation of them, they have never said that it should be 65. They are saying that that it should be 65, which we feel. So then let us put the proposal to the government to increase it to 65. This is their interpretation. Their interpretation is not to that effect that it should be, we interpret and the government decide is 65. That's not the interpretation.
Yes, my lord, that is not what I am suggesting. My case is that as notified by the government from time to time, that notification of the government has to be in consonance with page 78, whereby the age has already been increased to 65 years.
But that is what the government said. The government said that we are only limiting to educational institution and medical colleges.
That's why, my lord, this classification is not reasonable, my lord.
So therefore, the moment you are trying to bring that notification is a notification as the government may decide. The moment the government says that we are not doing in respect to this, only medical colleges and education. So therefore, your government decides is not being exercised and rule 60 becomes your age. Then your necessity is for challenging rule 32.
My submission is that rule 32 has not curtailed my right, my age to be 60, my lord.
Obviously,
It's open.
you see, rule 32 says two aspects. It should be 60, oblique, and as or the government, as may the government may decide. Okay.
Yes.
Now, your case is that look here, the government has already decided to make it 65 for professors
Hmm.
in educational institutions and medical colleges in the cabinet memorandum. So kindly give it to me. I'm also this is also an educational concern. What does the government say? Government say that this is not an educational institution, it's a research. The moment the government says that, that part of the rule where you are saying 60 or the government may decide is already been done. Now you require that this court has to say that no, it should be 65. My question is, can this court direct the government to do that? Because it is research should also be included as educational, more particularly taking into account that you are a society.
That positive direction, perhaps Lordship may not like to pass, but if the ground, again, my coming back to the original submission, that classification, if the classification itself is not reasonable, my lord, then definitely Lordship can only to that extent that this kind of classification is not permissible. I have charged, my lord, I have not found any case law which deals with exact this
Obviously,
issue.
no, except that recently that order which was passed by the Supreme Court recently saying the district judges cannot be equated with government servants. That's the only order which I could find. Where the government, then also the Supreme Court restrained it themselves and said that let the government consider then also.
That is what, let them consider if.
But
that-
the question is, should this court go into that endeavor? More particularly when you are a society.
But the same rule, my lord.
You see, the question is, the main fundamental question is you are a society.
Yes.
Problem lies there. The moment you are a society, maybe you are granting either of them. You are doing it under a memorandum of understanding. You have your employment. You are employing yourself. You are doing everything by yourself. So under such circumstances, can this court say that in respect to this institute also they are entitled to par with the government?
Well, ICSSR, the funding agency, is also a registered society, my lord. ICSSR, who funds 45% of the revenue, is also a registered society. And they have their professor, they retire at 65 years, my lord.
Very good. You go there. It's the only way out. No way out.
And in fact, my lord, regulation 32, there is a provision for at 32(2), provided that the governing body may, on recommendation of the chairman, in very exceptional cases and in the interest of OKDIS, re-employ any such faculty, academic staff for total period of not more than 2 years, but not exceeding 6 months at a time. There is a provision. What I am trying to say that 60 is not absolute, my lord. If your lordship looks at 32(2), there is a provision that it can be beyond 60.
An extension.
Extension.
But that is not the case here.
That is not the case, my lord. That 60 cannot be said to be an absolute age, my lord.
In
As per
fact,
the regulation itself.
recently I was going through, I think, the judgment of Justice Bhatti or something to that effect. What is the status of a person who is in re-employed? This was in respect to the Central Industrial Tribunals, very recent judgment. They were asking at par with the salary at par with the presiding officers of the industrial tribunals. The Supreme Court says when you are in redeployment or re-employment, your status is you are complete different from the persons who are actually in employment. So you cannot ask that.
Yes.
So here it is a case of extension being granted. They consider they can give an extension, that is their lookout. I'm not on that.
Yes, yes. I'm trying to say that 60 cannot be treated to be an
No,
absolute age.
Mr. This is too far off. Far-fetched.
And in fact, my lord, one judgment of the Supreme Court. This is with regard to age of superannuation of doctors, my lord, not in respect of professors. North Delhi Municipal Corporation, my lord, 2021-17 SCC 620, 642.
Yes, what is it?
Operative part, lordship will find that paragraph 22 and 23.
Paragraph?
22 and 23. May I read, my lord?
Hmm.
The common contention of the appellants before us is that classification of Ayush doctors and doctors under CHS is different categories is reasonable and permissible in law. This, however, does not appeal us, and we are inclined to agree with the finding of the tribunal and the Delhi High Court that the classification is discriminatory and unreasonable, since doctors under both segments are performing the same function of treating and healing their patients. The only difference is that Ayush doctors are using indigenous system of medicine like Ayurveda, Unani, etc. And CHS doctors are using allopathy for tendering their patients. In our understanding, the mode of treatment by itself under the prevalent scheme of things does not qualify as an intelligible differentia. Therefore, such reasonable classification and discrimination based on it would surely be inconsistent with Article 14 of the Constitution. Paragraph 23, my lord, the doctors both under Ayush and CHS render service to patients, and on this core aspect, there is nothing distinguishing them. Therefore, no rational justification is seen for having different dates bestowing the benefits of extended age of superannuation to those two different categories of doctors. Relying on this judgment, my lord, Madhya Pradesh High Court, my lord, I have come across. Here, my lord, facts has been stated at paragraph number 3-4. A rule was framed whereby age of superannuation in respect of allopathic doctors were raised to 65 years, but veterinary doctors were left out. That rule was challenged, my lord, before the division bench of Madhya Pradesh High Court. The case of the respondent is at paragraph 5 and 6. The respondents have filed their reply in WPC so-and-so and adopted the same in all other writ petitions wherein they have rebutted the averments made in the writ petitions. The respondents stated that the fixing of age of retirement of any employee falls within the domain of a policy decision and is exclusive for prerogative of the employer.
Show me where any researchers in granted.
That I have not come across. There's in respect of research institution, my lord, that has not been, I have not come, but my submission to that effect will be.
These are all doctors. I use veterinary, whatever may be, these are doctors. Question is whether any researchers in the state of Assam has been granted. Then also this court could have thought.
That has not, I have not come. But one judgment of Calcutta High Court I have found, my lord, 1966 judgment, where Asiatic Society, an institution, was said to be an educational institution. Publishing of research documents, a single judge's judgment, my lord. The issue came before the High Court was whether the institute can be called as industry under Industrial Dispute Act. in this
Ah, this
context.
is a different.
Now, in that context, my lord, in that context,
No. That,
in that
uh,
context,
with reference, you see, I still remember the judgment, I think it's a 1970,
now, my lord, kindly read paragraph 16 once, my lord, of the judgment.
1984, 85. Paragraph?
Paragraph 16. Here it is said that education cannot be confined only to classroom activities, my lord.
Then?
Now, here it is a research institute. Again, my lord, coming to the reason for not enhancing the age, it is stated to be that it is an educational institute. They do not carry out classroom activities. It is true that the petitioner does not impart education to pupils or students in the manner in which a university imparts such education. But can it be said that imparting of education in the manner in which it is imparted in educational institute is the only means of spreading education and learning? I think not. Education and learning can be spreaded not only by imparting education in closeted circulation of classrooms, but also providing facilities for research by publishing learned papers on so and so, my lord. These are the only judgments I have found. Read with that division bench judgment of Kerala High Court.
Well, look. Paragraph 6 and 7. See, the thing is that whatever the Calcutta High Court respect have stated, that has to be taken as an obvious. That was not the issue there.
Yes.
Issue is whether it will become an industry. Now, the question is whether it becomes an industry or not is a case, whether it falls within the industry, whether a research institute would fall within an industry, went into and said anything more. That cannot be said to be a ratio.
Exactly, man. But what I'm trying.
May at best be an arbiter.
Yes.
But ratio also, I'm not bound. But whatever may be, it may be taken as, yes, it may be a form of an education, which can be so and so.
Correct. It is well settled. Article 14 does not take away.
Not take away from the power of classifying person for legitimate purpose. And legitimate, even if such classification produces inequality in some form, it would not offend Article 4. Does not mean that every universal application for all persons who are not attainment or something. The classes are different and varying factors will require separate treatment. The main problem is On the question of classification is a very difficult thing. Unless some researchers were given out here, and this court could have said something.
Why I'm saying, my lord, if a person from this institute, assuming a situation, goes on deputation to another university, there is permissibility, my lord, they can go. If they get permanently absorbed there, automatically they will retire up to 65 years. Had it been so different, my lord, that institute being a society, in fact, this service regulation itself says that people can come from, on deputation, people can come here. And from people from this institute can go to other universities also.
In out here, the stenographer's age is 60. Gauhati High Court.
My lord?
Gauhati High Court, I think stenographer is 60, isn't it? 60. If he tomorrow goes to DRT and is absorbed, he gets 62. So should we make it 62 here also? My question.
Yes, yes.
Should we?
No, my lord, in that case,
That is beyond very difficult to accept. Very
because,
difficult. It's too
because
far.
my lord, the state government, all the two sponsoring agencies, state governments, their professors retire at
Anyway,
65.
because of your so much of arguments, I will make a CAV and think and ponder if I can pass anything. Very difficult, Mr. Counsel, but let me think if I can. Let me just make my own research very difficult. Only on the aspect. If I do so, I will only say about the classifications.
Yes.
Nothing more than that.
Yes, but only
But
that
I'm
much.
telling you, it's very difficult.
No,
And
because
I don't have the habit of just sending it to them for consideration.
now why I am saying, my lord, in earlier judgment of
Because you
the-
see, this petitioner has already passed the age of superannuation. I don't want to give him a false hope and sending for them to consider. No,
yes,
I'm not.
yes,
My order would be specific to the effect that he should either, if I find out anything,
yes,
your judgments I'm not satisfied. But then also, because the Ayush judgment is different, all these things. And
Yes.
Ayush has been referred to a larger bench, I'm told. The Ayush judgment, I think, has been referred
I
to a
am not
larger
aware, my
bench,
lord, I'm
taking
sorry.
into account the issue is involved on the parity and all. But be that as it may, without, even on that judgment also, the court says that there is no intelligible differentiate between Ayush doctors with allopathic doctors. That is another
and
thing.
in fact, the
But
Jabalpur
for
High Court has taken.
applying a researcher, yes, if there was another researcher out here in the state of Assam who is being given something to that effect, then the court could have looked into it in a different manner
Yes,
and said, but your problem boils down to the society.
yes, that is something, my lord, beyond the control of the petitioner also. Whether
I know
yes,
that it is beyond the control, but the problem also lies there. You see, in your case, if I gave, so problem is, see, what is the recognition to be given to the society merely because it's a grant in need? The society is regulating in all its own
yes,
procedures. The manner in which they will be recruited, the manner in which they will be terminated is as per their own regulations. The age is also not imported from the UGC.
yes,
The age is not imported from anybody else. It has its own regulations. So therefore, the society is regulated by themselves.
yes,
Now the question is, can this court, in that regard, equate them with any other institution or university which is done under the legislation? That is another aspect. So merely because of a grant in it, can this court do it? It's a very
whether
difficult.
this will, Lordship will kindly see while whether this will, the object sought to be achieved by establishment of that institute, whether it will be defeated if this system of retirement is kept, my lord. There is an object sought to be achieved by establishing this that has been spelled out in the memorandum of association, my lord. Whether with this,
Well, Mr. Counsel, again, this is too far-fetched. The object sought to be achieved is for 60 and 65.
no, my lord, object sought
Keeping
to
it
be,
at 60. No, the
object sought to be achieved with the establishment of the
Why-
institute, my lord.
No, Mr. Counsel. while deciding the issue before me, I'm not going to look into the object sought to be for preserving that institute. No, that is not the object for the purpose. The object sought to be it is to see as to whether there is a case of distinguishing a researcher with the institute education with a professor of educational institution. Well, what is the object sought to be achieved?
Yes.
That is the object, not for the purpose of preserving. That is too far-fetched. Anyways, you have made the argument, so you have, at best, you have got one thing is that I have made it CAV. I don't have a CAV, so only one CAV, but very difficult.
Paragraph 8, 9, and 14 is my.
But
Paragraph 4 ICSSR. I think that those paragraph
you give it on writing, the one thing, just one page, give it to me.
Lordship requires me give a synopsis of argument, my lord.
No. What is there to argue? If I want to hear you, I can just put on the video and look again to what to hear you. What is there? Now, earlier days of giving synopsis of arguments is what? There, the court may not note.
Yes, my lord.
But today, if I feel like, I can very well, okay, let me hear what Mr. So-and-so has stated before me as regards this, and again here and refresh my mind.
Yes.
This is the good part of live streaming.
Yes. I'm obliged.
Okay, hearing completed, judgment reserved. Give your names. Who is
My lord.
there. Only for him I am saying because he did not say anything about 4.
Yes.
For that, which paragraphs you want to rely upon, that's
Right.
all. Nothing more. The others I have seen it. He has said that, he has referred to. And in the meantime, you want to file it, you file, bring it on record if you get it. Once you get it, you just inform me in the court. Then I will pass an order to that effect. It has been filed and attention has been drawn that I'll put it in that order.
Obliged.
Deeply obliged.
There was a query on the last occasion as to how we have paid the rehabilitation grant if it is a private negotiation for sale. So on to that aspect, there is a government memorandum, particularly for Oil India Limited itself, wherein this provision is there, and so therefore we are complying with that. If I may just place this. Insofar as that rehabilitation grant aspect is concerned, the other issues, though, I mean, that is different. This deals with bipartite settlement negotiation only. Sale and purchase also.
Mr. Sharma, how is this relevant?
No, Lordship wanted to know if this
No,
is a
my
private.
question is here. There are various forms of acquisition.
Yes,
This is the case where you are acquiring.
under the TP Act, basically. Private
No,
negotiation.
this is not. In this case, you are trying to acquire the land by way of a purchase.
That's what.
Purchase is different from a land which is being acquired on the basis of land
Agreed.
acquisition.
Agreed, Lordship.
Now, when it is being acquisition is being done, then they say that look here, you pay as per the right to fair compensation act. This is what it is saying. There's nothing else which is being said. This is not a case of rehabilitation. No. So where is the question of rehabilitation comes? And if it is so,
This
then in that case, it has to be with the owner. Why on earth have you only negotiated with the respondent number, Mr. Ford? Because you see, the rehabilitation, if you are going as per this, then it has to be with the owners.
the money has ultimately gone to the owners.
No, I'm not
Out
on
of-
that.
out of
No,
all the
no,
owners.
no, here is the case. The money has gone. He has not given his authority for him to take the rehabilitation on his behalf. What he has given, an authority to the power of attorney to sell the land or the rights in respect to the land to so and so, to you.
Yes.
And that power of attorney, whether it has been cancelled or not, that is a different aspect of the matter. But the fact remains that there was a power of attorney at the time when the agreement for sale was there. And therefore, in view of the principles of agency, the doctrine of holding out will apply, and therefore the petitioner cannot go back from there.
Yes. Attracts the
He's
principle of
bound by
estoppel
that.
too.
There's no quarrel with that.
Yes,
He's
yes.
bound by that. But my question is, why have you involved him? If you are paying a rehabilitation to him, then although this circular does not say so, this circular does not say so of rehabilitation.
So it-
What does this circular say? That if you are acquiring land for the purpose of drilling or exploration,
Yes.
then in that regard, you pay the land compensation, of which if it is the distance is within 10 kilometers, then pay the land and the jirat, and the land has to be with a multiplication of 2. If it is multiplication of 1.5, and if it is beyond 10 kilometers, which is otherwise the state government's notification also, if there is an acquisition, it will be 2.
So this memorandum,
Does this memorandum say about rehabilitation? No.
this memorandum is specifically and for the purpose of bipartite settlement and negotiation that has been presently been done with the owners of the tea estate. The very fact, because it also gives a narration. Why? Because the fact is, Oil India keeps on requiring land, and it is the owners, they don't come up to give their lands. So therefore, this particular scheme was devised, particularly for Oil India. The heading itself speaks, Your Lordship, for bipartite settlement negotiation. It's not for acquisition. It is basically for the purpose of sale purchase, wherein a circular has been given to All India Limited, Lordship. If Your Lordship will just see the subject. This-
Have you looked into the provisions of section 26
Of
of
the-
the right to fair compensation? It says about a consent award.
Yes.
It says that irrespective of all these things, there can be a consent award. And when you are having a consent award, provide this. This is the Assam Mala project also.
Yes.
Where the state government has come up with a project that when we require land for PWD,
Yes.
we will have it on the basis of an agreement, and we will pay him this amount. This is for the purpose of acquisition. No, but here is a case where you are already acquiring by way of a purchase.
Yes.
Then where is the question of paying rehabilitation? My question is there.
So my specific instruction from All India Limited is that this is the policy being used. Even
Okay,
in a
let us
private
let us
negotiation.
let us assume that because of that, Oil India doesn't have any problem in making payment. Further payments, you are making the payment. It's okay.
I'm just trying.
No, it's okay. Now, why have you only entered into, because if this is the memorandum which is there, which says about the owners, why have you entered into an agreement with that respondent number 4?
Because the respondent
He is
number
not the owner.
had represented the owners.
How?
That agreement was there, Lordship.
Let us see the
Lordship has
agreement.
seen that agreement.
No, let us see the
And
agreement.
one aspect before that, Lordship.
No, no.
All the owners have received the money. It is only one owner who has defected now. Because he is representing all the owners.
You take a seat.
Beyond record submission.
No, he can submit to that regard. He is appearing for, my senior is
No,
appearing for all
it's
the.
okay. It's okay.
Yes,
All the owners have accepted him. But where is the authority of the respondent number 4 to enter into this rehabilitation? On behalf of the owner, show me that.
Mhm. Rehabilitation.
Yes, Mr. Gupta. Where is your power to enter with an agreement for rehabilitation on behalf of the owners?
Page 267 agreement is between Babul Sonwal and my lord
Not-
Oil
not-
India
not
Limited,
that.
not with me.
Huh?
Babul Sonwal, who is the power of attorney holder, my lord.
No.
There are two payments at two different timelines.
Huh?
There are two payments at two different timelines. We are talking about the first payment of the rehabilitation.
I'm
He is
not
talking
on the
about the
I'm
second
not on
payment.
the rehabilitation agreement for sale. I'm not on the agreement for sale. Agreement for sale is done. My saying is you have received certain amount on account of rehabilitation. Where is the power of you to take the rehabilitation on or for and on behalf of the owners?
Six of
Two,
affidavit in opposition filed by the Oil India Limited, my lord.
266 regarding account details for deposit compensation.
Yes, my lord.
What is this?
Given by Babul Sonwal.
That's it.
This is for land compensation.
Also,
This is for land commission. My question, you see, Babul Sonwal, has he given further delegation to you to collect the money?
Babul Sonwal has.
No, you see, he has, Mr. Sharma, you have made the payment to the respondent number 4. On what basis? There is some agreement? Rehabilitation agreement?
That
Or
document
just
is
for the
not-
sake of it?
That document is not with me, Your Lordship.
You paid an amount of around 7 crores without the document.
That agreement is there. There was one, I'm just finding the agreement, Lordship. There is an agreement that is given by the HUF of the T estate to Natwalal Bhushan. He is appearing for him to run and manage the garden.
So
And
therefore,
thereafter,
does that agreement spell out that these owners have entrusted him to take all the money of whatever money he can get by selling off or parting it or rehabilitation grants or compensation he can accept on behalf of the owner? One line is enough. Find it. Where is it?
it has to be there because
It,
other
it
owners
cannot
are-
be there because what the manner in which the Oil India is proceeding, you could have very well said, "Oh, forget about that. Rehabilitation, we have lot of monies, we have given it to him. Matter is over. We are not bothered. As regards this, I'm selling, purchasing it. What right he has? You could have very well say. But why are you paying him? Unless Oil India is somebody's, I think your Oil India people should be brought within the purview of some investigation.
So page 41 of the
Why is
stay
it
vacating application,
Huh?
there is a stay vacating application on record.
Ah,
In the
Stay
stay
vacating
vacating application at page 41,
vacating application.
there is a agreement at page 41.
It's stay vacating application.
which has been entered into
Because he also doesn't have any document. That is why he is referring to that.
No, that is a different aspect.
No,
There
that
are
is
two different transactions. One is
You see, the question of you paying him rehabilitation compensation or a compensation in terms with the office memorandum which you are submitting. You are paying this amount
yes,
in spite of the fact that you are purchasing the land. Is another aspect.
yes.
So if you are paying this amount, this is to be paid to the landowners. As per this.
It has been paid to the landowners.
No.
Through the
True means true. The moment he has to be a true, there has to be a document for the true.
that is what I'm trying to.
That is
Yes,
what
at
I'm
page
also finding
41.
it out. Yes.
Lordship will see that application. Stay vacating application.
Yes.
Page 41. This is the agreement between Khatangpani Tea State and Lordship will see the second party. One Bhanu Sharma, Sri Kuldeep Sharma, and Sri Natwa Bhushan Sonowal.
Where's the power? Where's the power?
And if your Lordship will see page 43, and whereas number one, the objective for this agreement.
Mr. Sharma, you seem not to have read this document.
I had.
You have not. Otherwise, you would not have made this time. Asking me to read and whereas. You have started from whereas means you have not gone even to where and whereas.
No, it speaks about the motive of this agreement.
Whatever may
That
be,
is now
my
decided to make
question is this thing is for the purpose of running the machineries, the tea state, for selling the green leaves, etc.
Page 44. May I just read lots of page 44? Again, the whereas, the second whereas. And whereas there has been discussions and negotiations between the party of the first part and the second part, whereby the party of the first part has agreed to hand over the management and operation of the tea garden along with its tea factory, fully and particularly described in a schedule below on profit sharing basis. And the party to the second party has agreed to take on the management and operation of the tea garden along with the tea factory named and style Khatangpani Tea Estate situated in so and so district, full and particularly described in the schedule. So
therefore, I am saying you have not read it properly. Where is the power that he can collect the rehabilitation compensation?
this was an agreement of 2019, whereby this is an agreement of 2019, whereby the management and operation of the garden was handed over by Khatangpani to him.
Profit sharing basis.
Maybe
profit sharing basis.
But at the point of time when Oil India had gone to the garden to acquire by way of negotiation, it was he who was running the garden.
So
maybe based on this.
So
and the money
you paid him the compensation as owners.
And the compensation was thereafter paid to the owners through him. The
How?
owners have agreed.
How? Where all the owners brought within the fold, whether the owners have signed and received their documents, amounts.
All the owners
How?
barring the
How? Verbally.
that document must be there. It's not with me right now.
No, it appears it is not there with you.
It is not there with me.
Nothing could be there. And the moment you have brought this office memorandum, it means that there is something wrong with your Oil India. Because on one hand, you are acquiring the land by way of a sale.
Yes.
And then you are again paying rehabilitation compensation.
Based on this circular law, sir, because this circular
could not have come within the ambit if you are purchasing it, because the purchase is not required if you are going for acquisition. The acquisition will happen how? Normally, acquisition happens what? You see, this is being done in the year 2021, taking into account in 2020, the government has, from the first time, notified the multiplication factor. The multiplication factor, which was there in terms of the 2013 Act, was only brought in then. saying that those people, the thing which is beyond 10 kilometers, it will be 2, and within here is 1.5. And if you are within an urban boundary, then 0. That's it.
This formula is applied for bipartite settlement through negotiation also is what is being followed, Lordship. If your Lordship will see just the subject, because this is what is being followed and this is what has been asked to Oil India to be followed, insofar as sale process is also concerned, Lordship. If your Lordship will see the subject, kindly, Lordship.
Have you mentioned in your affidavit that you have given on the basis of this office memorandum?
No, because
Obviously, because there nobody wants to put a signature out there saying that. You are bringing it before this court. Why? I
Because
asked
the
you a
query was there from your lordship.
no. I asked you to file an affidavit, the query to that effect.
Last,
I
last,
made it
last
very
order,
clear to that effect on the last occasion.
last order of your Lordship.
Yes. On what basis have you done that?
Yes, Lordship.
And this is an affidavit filed by whom? 7 to 42. Who are they? You are there. Wait. A. Sharma, so
7
and so
to
submitted that he would obtain instructions. Yes.
What I was placing, Your Lordship, is that this was basically a case where he wanted certain information as to how the money has been paid and to whom it has been paid. To that effect, we had filed our affidavit stating that there was an agreement to sale. And prior to the agreement of sale, since Oil India follows their policy, now that Lordship was asked what is the policy. Therefore, I have placed this document to show that this is what we have been following. Based on the policy, we had first paid the land compensation, the surface compensation. Number 2 was the rehabilitation grant. And then this agreement was entered into with all the co-owners, including the petitioner herein.
Where this surface compensation, if you have paid, where is the bipartite settlement?
It is a
Where is the bipartite settlement? Show me.
settlement is the agreement to sale.
Agreement for sale is a
that is-
different thing. You are purchasing it by paying 7 crores something.
Nomenclature, what Oil India uses, bipartite settlement, is basically to mean an agreement of sale and thereafter proceed to a sale deed. Under the Transfer of Property Act in 54, the process, that is what is that is the contemplation of Oil India Limited.
I think we should direct the managing director of the Oil India to make an inquiry how this transaction happened. This is better off. It seems after all it's Oil India public in the limited company, so it's after all it's a government company. So let the government and Ministry of Petroleum look into this aspect as to how this is being done. How the payment was made to the respondent number 4. You could not have made it payment to the respondent number 4. Impossible. On the basis of a profit sharing agreement.
Let me take the instructions tomorrow, Lordship.
No.
All the documents relating to the payment. Lordship.
No. You are not prepared whenever the last time you said, my lord, I was not prepared with this matter.
Regarding this
And
aspect.
therefore I fixed this matter, giving you due notice that you prepared. And today also you are using whereas. Without going into even means I thought you should have read from end whereas, but you started from whereas.
I am just trying to place that this is the agreement based on which he has come into the picture. And thereafter, Oil India.
No, my question is, where is the question of making payment to them also? I'm not saying that you should have, there's a requirement. You may very well say that, look, you see, it's Oil India's money. We throw it to the dustbin, that is our lookout, so
not
we have,
saying that.
we have given it. And this happens, this appears to be apparent from here. On one hand, you have entered into an agreement for sale and paid 3.7 crores, of which the petitioner have received certain amount or not received, but it is being received by the, what you call that, by the power of attorney holder. He has received, so therefore that is one thing done. The second is as regards the other one. The other one, without an acquisition being carried out, how can there be a bipartite settlement also? This is an acquisition notification. There has to be an acquisition made under the Right to Fair Compensation Act. Tell me how, by way of a bipartite settlement, you can acquire the land. Tell me. Under what provision? On the basis of an office memorandum.
Yeah,
Mr. Sharma, are you saying before this chaos that on the basis of an office memorandum, can you acquire land?
have not acquired the land based on this memorandum. We have made the payments based on this memorandum insofar as a sale proceed or sale transaction itself is concerned, because this is what has been directed to All India Limited to
Then
follow.
how does the
Even in
respondent,
our-
if you have anything to do with the sale proceeds, how does the respondent number 4 come into the picture? Respondent number 4 under no circumstances could have come into the picture if you are making a sale proceeds. Because he is not the owner. He has a profit sharing agreement. He may have a right over the land or over the use, or if anything happens, he may lose certain amount for which he may very well claim against the owners. That's his lookout. But why the respondent number 4 has been brought in?
Today, my submission would be
You are not ready.
he was the occupier of that.
Show me. Yes, ask him to come here. Yes.
But initially in 2019, there was agreement between the authorized persons of the Khatangpani tea estate and this respondent number 4 to run the garden on profit sharing basis. Then thereafter, my lord, there are talks of purchase of the garden. In the meantime, my lord, this Oil India
Agreement for sale done.
no, that is not there. One MOU was signed, my lord,
For purchase.
for purchase of the garden.
You have paid certain amount.
paid certain amount, my lord, to the.
So because of that, you are claiming the right. Now you do a lot of civil work, civil cases. What is the second proviso to section 54?
Transfer of property act.
Yes. What does it say? A contract for sale is except a right to get the document, sealed it, isn't it? So where is your right?
No, my lord, thereafter what happens, my lord, Oil India, when they enter into the, my lord, agreement, my lord, then, my lord, the power of attorneys are executed in favor of Babul Sonwal, my lord. So Babul Sonwal, my lord, he has given this letter which I have shown to your lordship, my lord, page 266, my lord. And my lord, as per
No,
my
whether the Oil India entered into an agreement with Babul Sonwal.
agreement for sale with Babul Sonwal is there.
Agreement for sale is different. There are two. I think by now, you, Mr. P.J. Sakia, Mr. H. Sharma, all have understood. Even the others who have nothing to do with the case also have understood. There are two components. One is the purchase by way of an agreement for sale, where Babul Sonwal have been granted the power of attorney. That is one, which is around 7.5 crores or something. That is the difference, of which the oil have already paid 3.7 crores or something. Remaining will be paid at the time of execution after the permissions. This is one. We are not concerned to that. The second is, yes, Babul Sonwal could have entered into Oil India for the purpose of taking the rehabilitation, taking into account the power of attorney which was granted. Did Babul Sonwal enter? No. No. Did you enter with an agreement with Oil for receiving the rehabilitation package?
As per my instruction, there is no such agreement.
So Oil have paid you that amount on what basis?
On the basis of a letter given by Babul Sonwal. As per my
And the Babul Sonwal's letter is at page 266, which only says that the land compensation be paid to this account. Isn't it? And on the basis of that, Oil had made the payment without there being any document to the effect that 7.5 crores rupees is being paid. Isn't it?
And then, my lord, this respondent number 4 has paid to, my lord, all the landowners, my lord, he has totally paid about 11 crores, my lord. To the respondent number 4 has altogether paid about 11 crores to, my lord, all the 38 landowners, my lord.
11, you have got 7.
7 plus 3.5, my lord.
You have got 11 crores from them.
7 crores, and, my lord, apart from that, my lord, he has also paid for the sale consideration, my lord. That is also included.
What still?
He, since he intends to purchase the garden, my lord. This respondent number 4, my lord, although he is running the garden and also he has intends to purchase the garden. So he has altogether.
So you have an agreement for sale.
No agreement is signed till.
You have an MOU.
MOU, my lord.
Where is the MOU?
MOU at present I do not have, my lord.
Have you entered into an MOU with the petitioner?
Yeah, through the power of attorney holder, my lord, it was entered, my lord. The power of attorney holder, Babul Sonwal, he has signed the MOU for on the behalf of the petitioner, my lord.
When?
2000.
Have you revoked the power of attorney or not?
Yes, my lord.
Where is the document?
My lord, 14/6/2023, MOU was entered.
Both the councils.
Lord, the revocation was done subsequently. That is not part of the record. Lord, 184, Lord.
Is it a registered document? Where is it?
Lord, this is part of a subsequent writ petition, my lord. Also will kindly have.
Is another writ petition filed? What is that?
Lord, this has not come in the list, my lord.
This was done in 2026.
Yes, my lord. That has been revoked.
After orders being passed by me.
Agency of the writ petition, my lord.
So in the meantime, that again another agreement.
Lord, it was done immediately after execution between Oil and Babul Sonwal, my lord. Immediately after the agreement. It was certified copy obtained in 2026, my lord. And it was intimated to the Oil also, page 283, which was annexed to the pleadings of the present writ petition. Wait. 22/5/2024.
Did the MOU with Babul Sonwal contain a stipulation that you can collect the compensation?
No, in the MOU, there is no such.
This petition has not come up. Now, in view of this petition filed, now, what remains in this petition?
Which before your lordships today to take up this matter along with that writ petition. The reason is that this purported bipartite settlement and this MOU, they are repeatedly saying in all their affidavits and replies filed that there is an MOU, there is a bipartite settlement. If your lordships considers the affidavit of the Oil India Limited, everywhere they have used the word acquired. We have acquired by virtue of a bipartite settlement. But that purported bipartite settlement is nowhere there in the entire pleadings. They are, my lord, deliberately keeping it with them. Today, on the last occasion also, at the end, I make a mention before your lordships, when your lordships asked the Council for the Oil India Limited to bring the instruction that there was a bipartite settlement that has not been produced till now. Today also, my lord, they have brought an office memorandum but that bipartite settlement, basing on which they are saying that we have made the payment, that is not there before your lordships. They're keeping the records within themselves, my lord. No, the main two documents they are not bringing before your lordships. It's a fit case wherein your lordship is required to consider the records. You know, something more will come out here. Something more will come out if your lordships considers the entire records.
Now we give it to the CID to make an inquiry.
Exactly, my lord. This requires a
Because you see, after all,
money is
the
not
CID.
a factor, my lord. Factor is
No. It seems something is
public
wrong.
money.
It's a public money after all.
Money is not a factor.
We
The
require,
factor
is the Union of India a party here? No. I think we'll inquire, direct the CID to make an inquiry and submit a report. This is not how it is done. It is shocking to this court.
Absolutely.
After all the money which is there, you could not have given. And did you also inform the petitioner by way of a letter that look here, we are paying this amount on the basis of this?
My lord, when the surface compensation was paid, a letter is written by this respondent number 4 to the authorized persons of the Katampani Tea Estate, my lord.
Did you write it to the petitioner? I'm
No.
concerned not with others. You see, Khatangpani Tea Estate authorized person is not there. Everybody is the owner.
But they have authorized, my
The
lord.
moment you are entering into an MOU with the Babul Sonwal, which you are saying so, if you are saying so that you are entering into, Babul Sonwal entering into with the agreement for sale on behalf of everybody, not with the authorized persons, meaning thereby everybody is the owner, co-owner. So did you write it to the petitioner that this is the compensation which you are paying for surface compensation and this is the amount which we are paying on account of the sale? Did you mention it?
There is no written communication, my lord.
But it is just put in the bank account.
But it is transferred to all the landowners' bank account, my lord.
No,
Money is
who has asked you to do that?
there are talks in between the my lord, the authorized persons and this respondent number 4, and then, my lord, the money.
Again, authorized persons. Who are the authorized persons on behalf of the petitioners?
But this one Ritesh Sharma and my lord, there is one letter, my lord.
The documents are there. It's
So?
HUF, and the HUF Karta has given it to two of the co-owners, Ritesh Sharma and the other person. And they have thereafter entered into agreement.
Mr. Counsel, HUF is different. HUF is for the purpose of managing the tea garden, tea state. Tea state is being managed by the HUF. But the ownership of the land is not the HUF. Ownership of the land is every person who has derived the title from those 4-5 persons. And this is an admitted fact by the fact that you have entered into an agreement through Babul Sonwal with against each person. So therefore, you cannot come up with this excuse of an HUF. HUF is only for the managing the tea garden. Managing the tea garden is different from owning the tea garden. So therefore, he has no business of making the payment to you. You collect the money from the registry.
My lord, pursuant to that, my lord, understand.
And we direct the, I think this is a case of CBI.
Lordship will allow me to come.
No, no, CBI,
Give me
CBI.
1 day time. Tomorrow
No, no.
I'll get all the instructions and I'll also get a person from the land department who can explain.
Tomorrow, if it is tomorrow, then it is a 50,000 cost upon you because you are not prepared. I've spent half an hour, 45 minutes today. And tomorrow also not possible. We'll have it on some other day. But that every day, it's a 10,000 rupees cost upon you. We have sold so much of time. Every senior counsel is waiting out here because of you. You are not prepared and come before this court.
What basis we have made the payment?
That could not have been the basis. That is why I am a. If this is the basis, I'm putting it. If this is the basis on which it is being done, there's not a single agreement entered into between so and so and so and so. This is a case for a CBI inquiry. I ask the CBI to make an inquiry because this is, after all, the involvement of all this thing. Let the CBI look into this. This is not a
Because Lordship had asked for the instruction on what basis. So I have produced this circular on instruction from All India Limited to say that this is the policy or this is the memorandum based on which we are making the payment.
Okay.
Now, why we made the payment to Natwa?
Okay, let me pass. Let me pass an order. Wait.
Lordship, I'm ready to pay the cost also, but Lordship will give me 1 day time.
Heard Mr. H.K. Das, the learned senior counsel, appearing on behalf of, assisted by so-and-so, appearing on behalf of the petitioner. Mr. A. Sharma appears on behalf of the Oil India Limited. This court, by an order dated 5/8/2026, sought for instructions from the learned counsel for the respondent number 1 and 2 as to why a rehabilitation compensation was paid to the respondent number 4 when the respondent number 1 and 2 have purchasing the very tract of land at measuring 40 bighas. And in that regard, an agreement for sale have already been entered into. Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner, respondent number 1 and 2, have placed before this court an office memorandum dated 5/7/2021 to justify the payment of the rehabilitation compensation to the respondent number 4. A perusal of the said office memorandum dated 5/7/2021 reveals that the said compensation is in respect to acquisition of land by Oil India Limited for exploration of oil by drilling. For exploration of land oil by drilling. And therein the minimum compensation have been spelled out. Irrespective of the class of land, in other words, this office memorandum dated 5/7/2021 is providing a compensation which is compensation for acquisition of land and providing better benefits than what is envisaged under Schedule 1 of the Right to Fair Compensation Act. Be it as it may, it is very pertinent to take note of that the acquisition of land is not only limited to payment of compensation, but there is a manner prescribed under the Act of 2013 which requires a notification under Section 11, a declaration under Section 19, an award to be passed by the collector, and thereupon possession to be taken. It is only upon the possession being taken, the land would vest upon the acquiring authority to be given, handed over to the requiring authority, requiring entity. Under such circumstances, it is very difficult to appreciate that without even initiation of a land acquisition proceedings by the collector of which district? Tinsukia. Why surface compensation was paid to the respondent number 4? When this court inquired with Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2, he submitted that the surface compensation was paid on account of the respondent number 4 having an agreement with the HUF of Katongpani Tea State.
One more document.
No.
And the HUF have written to Oil India giving NOC to him. Page 92. Must kindly peruse that. Page 92 for affidavit. The HUF has given a NOC to Oil India Limited.
And in that regard, he has referred to the deed of agreement dated 5/2/2019. A perusal of the said agreement reveals that it is a profit sharing agreement by and between MS Kotongpani Tea State, which is the HUF, with that of the one Hanu Sharma and Sri Kuldeep Sharma, with Sri Bhanu Sharma, Sri Kuldeep Sharma, and Sri Latwa Bhushan Sonwal. It is also apparent from a perusal of the said agreement that MS Kotongpani Tea State is an HUF managing the affairs of the Kotongpani Tea State, whereas the owners of Kotongpani Tea State are distinct from the HUF managing the business of Kotongpani Tea State. Page
92 and 93 also. Of the affidavit.
Whose affidavit?
Our affidavit. Oil India. Contribution number is there.
Mr. A. Sharma further referred to
93 is the Karta writing to two of those. Page 93 will also see.
further submitted.
And 92 is The NOC.
That apart from the above,
The Karta writing to the members Ritesh Sharma and Shekhar Sharma, page 93. And 90.
that that one, what is his name? Shishu Sharma.
Shekhar.
Huh?
Shekhar Sharma.
One Shekhar Sharma claiming to be the authorized signatory of Kotongpani Tea State.
Authority is page 93 Lordship. Shekhar Sharma authority is page 93. The Karta giving the authority to them. Shekhar Sharma, Ritesh Sharma. The Karta, R.R. Sharma, Karta, J.N. Sharma and others, HUL. In 2017 only. Based on which the agreement was entered by them with Natwalal Bhushan. 2019 agreement.
Mr. A. Sharma, the learned counsel, referred to that on 23/3/2017, one R.R. Sharma, who was the Karta of J.N. Sharma and others, had confirmed that Mr. Ritesh Sharma and Shekhar Sharma, they are parties.
Their part.
And whether R.R. Sharma is there, alive.
Yes, alive. Alive.
He's still the Karta.
Yes.
If he's the Karta, did he sign into the agreement?
My
2019
instruction,
agreement, Lordship. 2019 agreement.
no.
That is been signed by these two persons because Karta has authorized them,
No, the,
Ritesh and Shekhar Sharma, in 2017. So therefore, 2019 agreement, office sharing agreement is signed by these two.
Mr. So-and-so, the learned counsel have referred to a document dated 23/3/2017 issued by one R.R. Sharma to Mr. Ritesh Sharma and Sri Shekhar Sharma, whereby both the later persons were entrusted to look after the tea state with immediate effect, which would include all aspects of operation, management, finance, accounts, liability servicing, and interaction with the government bodies, amongst others. Mr. A. Sharma submits that on the basis of the said authority, Sri Shekhar Sharma on 10/1/2022 have written a letter to the General Manager Land HOD, Oil India Limited, that Oil India Limited that he has no objection in respect to payment of compensation against crops. However, in the said communication dated 10/1/2022, it was specifically mentioned not to release the compensation amount against land value to any party except the recorded landholder. Under such circumstances, this court fails to understand as to why The respondents, number 1 and 2 have released the compensation in favor of the respondent number 4. When even the authorized persons whom the respondent number 1 and 2 recognize as speaking on behalf of the Kotongpani Tea State have asked the respondent number 1 and 2 not to release the land compensation in favor of the respondent number 4.
Land value. Land value is the purchase price of the land. For that, we have entered into agreement with all the co-owners. Our rehabilitation grant is not the land value. It was a grant given based on this notification or circular. This is the understanding of it. The language, compensation amount against land value. So therefore, for the land value, we had entered into agreement. Rehabilitation grant, we have not considered that to be a land value. Therefore, we have given it to him. I have to case my.
It's okay. I'm giving you the chance. Yes, what do you have to say?
Well, the same, my lord, I would like to reiterate what my, my lord, the respondent number 4 has said. I have said in my, lord, affidavit in opposition, paragraph 9, that for the purpose of this disbursement of 50% of the total compensation amount on account of land value, solicitude, etc., the deponent, as per the terms of the MOU dated 14/6/2023, and on the basis of the power of attorneys, requested Chief General Manager, Land Department, Oil India Limited to deposit the said compensation amount.
Who is the deponent?
Babul Sonal, the attorney for the, my lord, respondent.
So for 7 to 7, 42, Babul Sonwal is appearing. He has filed.
Yes,
Okay, we'll take note.
including, my lord, the Ranjit Rana Sharma is also there.
Have you produced the MOU?
MOU is not annexed.
We won't, I'll reject that affidavit then, your style, in view of paragraph 13 of that judgment. Don't worry. We'll take it.
Also, will record my submission that this is not land value that we have.
This court further inquired with Mr. A. Sharma that if it is the case not to pay the compensation pertaining to the land value to the respondent number 4, why the compensation, rehabilitation compensation was paid to the respondent number 4. Mr. A. Sharma, the learned counsel, submitted that the payment of compensation, rehabilitation compensation which was paid to the respondent number 4 was only for the Jirat.
Was paid as rehabilitation grant.
No, Mr. Sharma, don't beat around the bush. There are two aspects. No, Mr. Sharma. One is as regards the land value, and the second is as regards so and so crops. There are two aspects. Mr. Sharma, there are two aspects. No, you take a seat. You don't need that. Submits why illegally. And Mr. Sharma, if you disturb, I'm going to impose every minute time you disturb 50,000 each. And then keep your, if you have brought a car, keep the car attached till you don't deposit the amount in the registry.
Just trying to safeguard.
No, you take your seat. Whatever may be, you want to file an appeal before the division bench, but this is the order which you are getting. Take your seat. For the crops. This court also inquired as to what is the bipartite settlement which have been entered into, in as much as reference to that is being made in the repetition in the affidavits filed by the respondent number 4 as well as the respondent number 1 and 2. The learned counsels appearing on behalf of the respondent number 1 and 2 as well as the respondent number 4 categorically mentions that there is a bipartite settlement. Under such circumstances, this court directs the respondent number 1 and 2 to produce the bipartite certificate settlement entered into by and between the respondent number 1 and 2 with the respondent number 4 on the next date. There is also a mention during the course of the hearing, the learned counsel appearing on behalf of the respondent number 4 also submitted that there is a MOU entered into by and between the respondent number 7.
14/6/2023.
Respondent number 7.
Yes.
Babul Sonwal.
Sonwal is not a made party, my lord, in this writ petition.
MOU with whom?
With Babul Sonwal.
With you for the sale
Yes,
deed,
yes,
which you made a submission now.
Yes.
MOU.
MOU with the between the respondent number 4 and the respondent number 7. And it is submitted that on the basis of the said MOU, the respondent number 4 had the authority to collect the land compensation from the respondent number 1 and 2. The said MOU be placed before this court on the next date. Produce it.
May I submit my- Well,
Yes.
I have stated before your lordship that on the basis of the letter given by Babul Sonwal, the money was given to respondent number 4.
No, that is not the letter. Because if you want that, then obviously this court have to hold it. You didn't have the authority. You are saying about you had the MOU.
Yes,
Produce the MOU on the next date. This court further directs the respondent number 2 to be present in the court on the next date. Through the video conferencing link to be produced by Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2. Pusto. Mr. Sharma, you, Mr. Yeah,
I'm sorry.
Mr. Das,
Yes, my lord.
has your client lost all the money after paying it to the registry? That you don't have the money for annexing the power of attorney? Why have you referred to various things that I'm rejecting your affidavit with?
It is there on record, my lord. Aji affidavit one. Yes, my lord. Affidavit in reply filed to the IA, my lord. By
Where is the respondent number 7 to 42? Yeah, got it.
page, my lord will find 100 and page number 122, my lord. It's there.
Mr. Saikia,
of
where
that
have you mentioned about the power of attorney, MOU? Allowing the respondent number 4 to collect it?
page 311. Part of my affidavit in court.
Page 292.
Paragraph 3.1.
But did you have an agreement with oil? Did you have an agreement with oil?
My lord, the agreement to sell.
With oil for the purpose of the compensation, did you have an agreement with oil?
This is on the extent of the various power of attorney.
No, no, no. My question is, did you have an agreement with oil? Mr. P. The learned senior counsel appearing on behalf of the respondent number 7 to 42 submitted that the respondent number 7 have issued a communication to the Chief General Manager, Land Department, Oil India, to arrange, thereby requesting Oil India to arrange to deposit the land compensation amount payable against the land falling in Kotongpani Tea State in the bank account of the Kotongpani Tea State as per the details given. The said document is of relevance taking into account that the said attorney holder claimed himself to be the attorney of Kotongpani Tea State, and on the basis of that the said request was made. The respondent number 1 and 2.
Attorney was executed by individual members.
Have you mentioned it, Mr. Saikia? Read it, paragraph number, page 363. Read it. What do you mention? Have you mentioned it? That I am the power of attorney holder of all landowners, kindly pay? No. Taking into account the above, it appears that there is no agreement entered into by and between the respondent number 7 with the respondent number 1 and 2 for the purpose of in respect to the rehabilitation compensation. Nothing has been placed that the respondent number 4 had entered into an agreement with the respondent number 1 and 2, thereby authorizing the respondent number 4 to claim the compensation on behalf of all the landowners. Under such circumstances, a question duly arises as to whether the Oil India Limited, which is a public limited company, wherein the government of India is a public limited government of India enterprise, make payment without proper documentation. The respondent number 2, who is directed to be present on the next date, shall explain it before this court. Full stop. List this matter on 9th of September 2026 at 10:30 a.m.
One small correction, perhaps Lordship will kindly verify.
Oh, another thing. This court have also taken note of the affidavit in reply filed by the petitioners against the affidavit in opposition filed by the respondent number 7 to 42. In the said affidavit in reply, the petitioner have referred to various documents and without bringing on record those documents, taking into account the judgment of the Supreme Court in the case of so-and-so versus so-and-so reported in 1988 4 SCC 534, more particularly at paragraph number 13, this court would not consider the contents of the affidavit in reply where in respect to the documents mentioned which is not part of the record.
Documents.
Further to that, there shall be no further leave of the petitioner to bring on record those documents.
Fine, Lord, only small prayer. Respondent number 7, Lordship has mentioned in the order, my Lord. Respondent number 7, actually Babul Sonwal represents respondent number 4 to 42. 7 to 42, my Lord. He is not respondent number 7 here.
He's not a party.
He represented, he impleaded, got himself impleaded
As
to represent 7 to 42.
what is his number?
Not a party. He is not a my Lord, named party, but after serial number 42, he says all the applicants are represented by their attorney Babul Sonowal. So 42, 7 to 42 is represented by Babul Sonowal. He sweat the affidavit.
8 to 7 jo kaise Babul Sonwal.
Or it has to be only Babul Sonwal or Babul Sonwal representing 7 to 42.
No, others cannot be mentioned. First of all, how can these type of parties be mentioned like this?
No,
Babul
they have-
Sonwal has to be made a party.
He has impleaded himself in this manner.
I'll help you with that.
Fine.
They have impleaded, you should have said when the court was passing that order.
Lord, since Lordship was passing the order, my Lord.
No, when
Earlier.
that court was passing the order, you
Correct.
should have said
Correct.
that without the power of attorney being a party to the proceedings,
Correct.
he could not have been a deponent.
Deeply.
Yes.
The last two cases, my lord, yesterday your lordship prayer was made, my lord, the quarters, my lord, so far as we are concerned, my lord, our quarters, it was burnt, my lord. So all the documents, everything was burnt. But I got one slip, my lord, where quarter has been allotted to me, your so far as this is number 14. And regarding others, your lordship, according to them, it was allotted, but they don't have right now documents. It verified from my lord GMC, my lord. There is allotment against us also, my lord. This is the on 30th, my lord. Lottery, my lord. 1 quarter was allotted to me,
But this is not your case.
my lord.
This is not your case here.
Here, my case is, my lord, that earlier I was residing in 1 quarter given by GMC, my lord. It was burnt, my lord. Everything was burnt. So GMC has given me at that time, my lord, another alternative arrangement, my lord. It is true, my lord. They have taken taking that you have to vacate if it is required by them. But the question is this, my lord. My lord, if your lordship passes order, my lord, I have to vacate. But the question is, my lord, that where we will go, my lord.
That is not my concern. The others also have to come.
My lord.
They have also a right. They have been waiting all this while. For the
But they are,
allotment. And because of the pendency of the earlier petition,
my lord.
they did not get it.
My lord,
So
what
we
I'm,
can't help you with
my lord,
that.
what I'm
If
praying,
you have any allotment fee you are entitled to,
I
they
have
will
given
give
my
you
lord
some other
allotment.
land. No, they will give you, they will consider. You submit a representation to them, they will look into it in other. But here you need to vacate. Isn't it? They say that they have been also given allotment.
That is another plot of land where the fire has taken place. In the meantime, the case was going on, so we have kept it 33 as vacant. Then there was an application to
put in this person 33%, but with the writer that there's an undertaking. Moment the order comes up, then you have to vacate. Then the order is there. Thereafter the process has started. Notice was given. Then it could vacate. And this order, then we cannot.
And what is the undertaking? They have not filed affidavit also, my lord. They don't remember what is the undertaking they have given, but in the present proceeding, my lord, GMC has not filed affidavit. We have written that what type of undertaking we have given, whether we will vacate or not, my lord. Ultimately, my lord, GMC, because we are working under GMC, my lord, they are providing us, my lord, shelter.
They next all the notice.
Notice I have next.
There is undertaking that you have to vacate all this the moment the order comes up in these two connected cases. They knew it that when the order comes, if there is the order in favor of the petitioner, they have to vacate. It was temporary. They writer that they will undertake that they will vacate it.
And we are employed with GMC, my lord. I have annex identity card, but the employment number is also given, my lord. So we are working with GMC. We are doing work on behalf
Understood, but Mr. Goel, you have to understand there are others who have earlier claims, who have made earlier claims. So these people also need it, barely because of the fact that subsequently you have taken over out there, you have been asked to reside temporarily. You cannot have a right over the land.
I'm not saying,
All right.
my lord.
You cannot.
What I'm
Barely
saying, my
because
lord.
they are not. You were required to vacate when the writ petition was disposed of. Those writ petitions were
So
disposed
with the direction to allow this.
allot and consider. And thereupon you have considered and then you have found 33 is required, asking 33 to vacate.
Vacate, they said given to them, their notice was served to them to vacate it. Thereafter the petition has come.
How much time?
I will, my lord. Only one prayer, my lord. GMC authority, because they have allotted us, my lord. So far as, my lord, if your lordship direct them to, my lord, give possession of the, because quarter has been allotted, my lord. In fire, everything has been burned. One, my lord, as an example, I have submitted, my lord, before your lordship. There is an allotment, my lord. So your lordship may direct them to, my lord, regarding to give us alternative arrangement, so that, my lord.
First vacate. First vacate, then we consider. It cannot be both, my lord. You have given an undertaking. You were given, you see, Mr. Goel, you are not understanding. Tomorrow, just think about yours. I say that you consider them on the basis of this. Okay, they have a house to consider. But that house has been given to somebody for the time being, so that there is some litigation, that litigation is over, then once the litigation is over, the land will be taken over. Then how will you feel that in spite of an allotment you are not being given? Because that person has been given temporarily. You don't have a right. Your right came later on. These people have been fighting this case long time back. You are newly inserted. When did you come?
My lord.
How many years?
In the quarters, my lord.
Yes.
My lord, we are from last 40 years, my lord, we are residing there, my lord. We are sweepers, my lord.
No, there were another way. Now this is 33 houses. They came in early just before the.
After burn, after that incident.
When?
My lord, in the 24. Huh? 22. 24. No, before that it was given. Before that, my lord, fire was broken, my lord. I am on my lord 9/12/2022 fire. Thereafter it was given.
Absolutely no.
So prior to that, my lord, GMC has given.
9/12/2022. You vacate how many days?
My lord, will vacate only one prayer, my lord.
We will consider later on other things. First vacate 15 days. I give you vacate. In the meantime, you take over. Mister, you take over. Give it to them, whoever is necessary. Then we'll pass orders for consideration for other place. In the meantime, vacate 15 days giving you.
My lord, I have taken instructions. Can it be 3 months, my lord?
No, no, no. 3 months is too long. 1 month. 1 month. Okay. 1 month. We wanted before, the allotment should be made before the puja vacations. So that we can pass direction during the puja vacation, you consider how to accommodate them in some other places.
That observation, my lord.
Not now, first vacate. 1 month vacate, then we pass.
My
it.
lord, thereafter, my lord, if your lordship is not there, my lord, how, my lord, regarding consideration, my lord, after 1 month, my lord. So some indication so that it may be passed, my lord, after.
Not now. Not now.
It will
First
be
vacate.
considered
No.
such type of, my lord, after 1 month.
I think this is a fit case for dismissal, no?
Yes.
Fit case for dismissal. They have not been able to dismiss any case, so they'll dismiss. Whose is 1767 is whose case?
17.
Both these two cases.
70-67, both my.
देखो, both the petitioners heard Mr. A. Goyal, the learned counsel, appearing on behalf of the petitioner in WPC number 1695/2025. None appears on behalf of the petitioner in WPC number 1767/2025.
I'm appearing, my lord, 1716.
Both.
My lord.
Learned counsel appears on behalf of the petitioner in both the writ petitions. The petitioners have approached this court challenging the notices issued by the collector Gauhati Municipal Corporation on 21
1 2020.
1 2025, whereby the petitioners were directed to vacate the present BSUP unit at Potasil New Horizon Colony within a period of 30 days from the date of receipt of the notice, and to give peaceful possession of the same to the GMC authority. It is also mentioned in the said, further to that, in the said notice to vacate, it is also mentioned that the noticee, that is the petitioners, would not be provided any further accommodation by the GMC authority. Mr. A. Goyal, the learned counsel appearing on behalf of the petitioners, submitted that though the petitioners are temporary allottees who are victims of fire, but the petitioners are also GMC employees. Grade 4
Sweepers and Mazdoor sweepers.
are grade 4 GMC employees. Working as sweepers. The learned counsel submitted that prior to the petitioners being allowed temporary allotment, post the fire which took place on 9/12/2022, the petitioners were residing in
GMC allotted quarters. GMC allotted quarter, man.
in GMC allotted quarters which were destroyed by fire. Under such circumstances, the learned counsel submitted that the petitioners have no objection in vacating, provided some alternative arrangements are provided. More particularly, it is difficult for the petitioners to obtain any alternative accommodation in view of their profession. This way, I would have also heard Mr. S. Bora, the learned counsel. Mr. Bora, you need to do something for these people also. You consider also, in the meantime, they will vacate. But you consider also somewhere, because you see, one has to also understand.
Whether they have the original place, but that there's some consideration there, the building or something has to be done.
Do something for that area. Do something, work out some solution there, because they are your workers. And you also have to understand that taking into account their profession, they may not get places to rent also. It's very difficult for them. There is a genuine problem, so therefore you consider. Illegally too. Heard Mr. S. Bora, the learned counsel appearing on behalf of the petitioner, a respondent, a GMC, who submits that the petitioners have given undertaking for the purpose of vacating immediately upon the disposal of the three writ petitions, being WPC number 1822/2013, 1265/2015, and 3185/2019, to vacate. And therefore, they are required to vacate. In addition to that, the learned counsel further submitted that in view of the specific directions passed by this court in the judgment and order dated 3/10/2023, on account of the petitioner, the respondent in the GMC department is not able to effect compliance, for which contempt proceedings have been initiated. This court has given an anxious consideration to the respective submissions and duly the petitioners very well knew at the time when they entered into the possession of the respective BSUP units that they would have to vacate immediately upon the disposal of the three writ petition, being WPC number so and so, so and so, so and so. This court also cannot turn a blind eye to the rights of the allottees of these BSCPU units who have been fighting for these units since decades. Considering the above, this court is of the opinion that some period has to be granted to the petitioners to vacate. And also, certain directions are required to be passed upon the GMC authorities for Considering the case of the petitioners. Number. The petitioners herein are granted 3 months' time from today to vacate their respective premises. The respective respective units, BSUP units. The collector, GMC, who is the respondent number? Four. The respondent number 2, 3, and 4 are directed to consider number 2. Immediately upon vacating, the respondent number 2, 3, and 4 shall take effective steps for granting or handing over the possession to the allottees of the said 33 flats BSCB units. The respondent number 2, 3, and 4 further are directed to consider where the petitioners can be accommodated, taking into account that the petitioners are employees of the Gauhati Municipal Corporation. And there appears to be a genuine problem in finding an accommodation, rented accommodation. An update be placed before this court. By 7th of by 7th of December 2026. It is further observed it is further observed that if the petitioners do not vacate as directed herein above, this court have granted 3 months to the petitioner. To number 1, the 3 months to the 3 months on the submission made by the learned counsel appearing on behalf of the petitioner, that there would be that 3 months be granted to the petitioners. And if the petitioner do not vacate, the respondents number 2, 3, and 4 shall be at liberty to take effective steps for evicting the petitioners by evicting the petitioners at the cost and expenses of the petitioner. I gave you 3 months.
My lord,
In the meantime, file something, do something. That is what.
deeply obliged, Lord. I'm highly obliged.
What's the interim orders passed earlier stands modified accordingly. Your matter is there now. What happened?
2, 4, 5.
Your meeting is said. Yes, Mr. Dubey, your matter is there now, which I was supposed to take.
My matter is, my lord, item number 3, 4, and 5, my lord. Interim is there, my lord.
What is that?
My lord, contempt is there. Along with the contempt, another 2 connected matters were tagged, my lord, by your lordship on last occasion. The matter relates to, my lord, demand notice or issued against me, my lord.
What demand?
So, my lord, regarding PF dues, my lord, PF dues. The matter may be taken now. Entire my land has been taken. They have attached in violation of court's order, my lord.
Okay, take a date. Your matter, there is urgency. I am passed an interim order.
Yes, ma'am.
And will be taken day after tomorrow.
My lord, my also may be taken up, ma'am.
There is an interim in your favor.
Yes, ma'am.
You are enjoying it.
No, my lord, they have violated the interim order, my lord. That is why.
We'll look into it later on. But there I have passed a stay. So when I pass a stay, I am obligated to finish it off as soon as possible. More particularly tender matters. Anyway, so 28. Mistake কেটা আছে? Mistake নহব impossible. 25th. Let's take it on Friday at 2 p.m.
My lord, mine also. 3, 4, 5.
Not yours. This I'll take it.
Well,
And you have a stay vacating, na? Mr. G. Rahul, you have a stay vacating?
It is filed by the railways.
Okay. Your item is item number
26, my lord.
26 be listed on 21st. The 21st in the stay in the area of stay vacating column immediately after the orders.
My lord,
Interim order needs to be interim order past the list shall continue.
in my case, my lord, interim may continue 3, 4, 5. Date may be fixed, my lord.
Item number 10, my lord. Get a date, whatever you feel like. Yes, Mr. Sakya, what is your case?
9 will be taken up day after tomorrow, my lord.
What is that? What matter is that?
Regarding Khotian, the lordship directed us to produce the records we have filed the affidavit that we are the riot from for last 50 years.
Mr. Sekha, I'm telling you, we can't have it before 27th. 27th.
Date may be fixed, man.
No, item number 10, my lord. But would that matter?
Yes.
There's no urgency.
The lordship may fix.
It is the ACB's case. There's no stay.
No, there is no stay.
No, we have it on November. Okay. 16 November, 17 November.
My lord, item 8, my lord, will pray for a date, my lord, fixed date. Any date convenient to your
Well, what is the matter?
That revenue board matter.
Oh, that matter.
It was fixed at 2, lordship, but could not fix due to.
It's very difficult. There has been too many fixing at 2. Now they're fixing 2, fixing 3. Because of, you see, item number 1 took a long time to do.
Understand.
And you see, normal matters is difficult, not problem. But when it becomes those type of matters, new subjects, hyper committee and all. Anyways,
We just want a fixed date, man.
okay. 26th August.
At 2 p.m.
Item 7, your lordship. So I may be allowed to withdraw the writ petition with liberty. There is no interim order, your lordship. I may be allowed
What liberty?
With liberty to file afresh, your lordship. There are certain defects in the writ petition and
What
also
petition is that?
writ petition. We have challenged the cancellation order. We
Of?
have terminated tender process. In tender process, our tender process, our work was cancelled, your lordship. We came against that, your lordship. Certain defects in the writ petition and also some information I came to know subsequent to filing of the writ petition, which is crucial for the proper adjudication of the case. So I may be allowed to withdraw. and
Mr.
file-
P.K. Sharma, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition with a liberty to refile. The learned counsel appearing on behalf of the petitioner further submits that certain new materials have come to light which could be required to be brought on record, and taking into account that the said being a new plea, the petitioner cannot bring on record the same by way of an additional affidavit, and accordingly there would be a requirement of an amendment. Under such circumstances, in order that the matter can be taken up, those fresh materials which has come into light could be taken up, the petitioner may be permitted to withdraw the instant writ petition with the liberty to refile. Who is the other side? No objection? Mr. A. Gayan, the learned counsel appearing on behalf of the learned CVC submits that she has no objection. Accordingly, the writ petition stands closed on withdrawal. Liberty given to the petitioner to refile. bringing on record those fresh documents.
There is a IA in terms of disorder that may be disclosed.
May I please your
Obliged.
lordship?
For 16, it's a MSc appeal. Time for the respondent. So it is of 2013 matter. May I pray for a date, Lordship?
What is the matter about?
I am the, I was the claimant. I was the claimant.
What is the matter about?
The respondent, now the person.
You are not ready.
No, sorry. Now the appellant has challenged the trial court order on the and said that the order has been passed.
No trial court.
The tribunal's order.
This trial court.
The tribunal's order.
Then
The tribunal's order. The award is of 8,12,000, and the accident occurred in the year 2007. My
what is the
husband.
ground of appeal?
The ground of appeal is they are challenging that in the criminal case they have been acquitted.
How that has relevance?
No, they have taken
That's the
that
only
plea.
ground.
Yes.
Well, tomorrow at 2.
May I please your lordship?
If it is further ground, then it will go after 10 years.
Lordship.
My lord, item number 11, lordship, intermediate passed earlier.
Yes.
Item number 10, my lord, I was on legs while I was here only, my lord, but suddenly the matter was called in 18, code 18. My lord, date may be fixed for item number 10, my lord. It was fixed at 2 today, my lord.
The fix is on 17th of November.
A bit early, my lord, on before vacation, October, Puja vacation, my lord, on October.
Wait, I won't be here from 14th to 23rd. Okay. 17th of September.
My lord. Much always.
Lordship, item number 22, 23.
With the winches. Both of you together means winches.
We were directed to file affidavit. They have filed their affidavit. But in the meantime, there was flood in ONGC's office. The whole office is not working right now. They're working from a hall now in a makeshift basis. But I pray for 2 weeks more time to file.
Okay. That matter is item.
22, 23. In 23, they will be filing affidavit.
Now you see, you have filed that affidavit.
Yes,
So thereby you brought in
yes.
this new aspects. So against that, they will file a reply. Yours 23 has almost become, I'm just keeping it.
Mm.
I'm only keeping that 23 alive.
22, 20,
Whatever with the second writ petition
Yes.
which was there, I kept it only for alive for the time being. You have not challenged the review order. Have you challenged the review order?
My lord.
Well,
Yes.
That is why I have kept the 23
The
alive.
filing number I have got, my
Understand?
lord.
but they've not served.
No.
That is why.
And-
I could have finished it on that day. I didn't because of this. Anyway, let them do it. Because if I had closed it on that date, you will have nowhere to go. So therefore, I didn't allow. Anyways, okay, how much time? Weeks time. We finish it off early so that his repeat appeal becomes infructuous. Don't you think that? Okay. Let's have it on 10th of September. In the meantime, file your.
Obliged.